Good afternoon, everyone. We are back on the record for our afternoon pretrial docket. We have a number of counsel on Zoom and also here in person. I don't have a sign-up sheet, so whoever's ready. Ms. Peskin, McGee?
Judge, I'm actually waiting for my client to come out, so I'm.
Okay. Counsel, my first time meeting you, so I don't know your last name.
Your Honor, Alyssa Grant on behalf of Mr. Swigert.
Okay, come on up, Ms. Grant. And who's your client?
Mr. Swigert, he's number 83 on the docket, 25 CT 0002.
Okay. Perfect. Is he with us this morning,
Your Honor,
afternoon?
we do have a waiver that was previously filed for his appearance. I'm just appearing on his behalf today.
Okay,
We did just recently receive an offer from the state that I'm going to be reviewing with them. So I am requesting that this be set on the next pretrial docket.
we can come back in July or we can come back in August.
August would be best because I believe there's going to be another attorney coming in on this.
Okay, that's August the 12th at 1:30.
Thank you very
And
much.
if
Your
it's
Honor.
simply just going to be a pass, you can appear by Zoom. If
Okay.
you want, just email my office and we'll give you that information.
Thank you. That's all I have. Your
All
Honor.
right, take care.
Have a great day.
Ms. Peskin, or you said your client is still in the back, counsel?
Yeah, I can address a couple, Your Honor. First case I have is Jacob Collins.
Mr. Collins with us or waiver?
Waivers on file, Your Honor.
Okay.
We just received a plea offer in this, so I need another month to talk to him, but hopefully it should resolve at that point.
July or August?
Let's do August just to be safe.
All right, that'll be August 12th at 1:30.
I also have Vanessa Ryan, Your Honor. We have depots on this on August 27th.
All right, Ms. Ryan, present or waiver?
Waiver, Your Honor. So I'd ask, I guess, for maybe the September date,
When are your depots?
August 27th.
All right, that'll be September 9th at 1:30. We have any issue with speedy trial?
We'll waive it if there is one. And Your Honor, the other one I can take care of right now is Jacqueline Bryant Kohler, and she's present. Come on up, Ms. Kohler.
Ms. Kohler, how you doing?
Fantastic. How are you?
Doing well, thank you.
She's prepared to enter into a PTI this afternoon, Your Honor. Would you like me to go over the terms of that? Okay,
I will just, she has to sign the PTI agreement and that's the agreement with the state. You just get it filed and hopefully, Ms. Kohler, I don't have to see you again. You could satisfy the conditions and the state will dismiss the charges, okay?
Thank you.
All right, so we'll take you off the docket.
thank you. And I'll be back when my other guy comes out.
Thank you, counsel.
None of this has to be changed.
Good afternoon, Your Honor.
Hey, good afternoon. How are you doing?
I'm well, thank you. Homer McMillan with Studstill Law at 25 CF 55. Ms. Charlene Hensley's president of the courtroom. She'll come and stand to my right.
All right, Mr. McMillan.
This is a change of plea, Your Honor.
Okay, good to see you in person. I know we've had other matters together.
I'm sorry, Your Honor.
Said we've had other matters together, but it's good to see you in person.
Thank you, Your Honor.
And this is Ms. Hensley? Okay. Whenever you're ready.
Thank you, Your Honor. In consideration for Ms. Hensley's no contest plea to fleeing or eluding a second-degree felony, operating a motorcycle without a license, a second-degree misdemeanor, and giving false information to a law enforcement officer, first-degree misdemeanor. In consideration for her plea, she'd be adjudicated guilty, should serve 48 months probation, and court cost fees and fines, $340 in the public, or excuse me, 20 to Crime Stoppers, 60 to court construction improvement, and any other pleas, any other fines that the clerk could inform me of. And 1 day credit for time served on the misdemeanors, 100 hours of public service to be performed at the direction of a probation officer, $20 monthly cost of supervision, drug and alcohol evaluation, DHSMV, the Department of Motor Vehicles, may apply additional penalties, time served on the misdemeanors. We stipulate to the facts alleged, agree to the imposition of minimum costs of $100 per felony and $50 per misdemeanor, and a DNA sample we understand will be taken, and the forfeiture of any seized items and 1 year driver's license suspension. I have my client's signature on the plea agreement. May I approach?
You may. Ms. Hensley, you'll raise your right hand for us. Ma'am, did you hear the announcement of your counsel about how you're going to resolve this case?
I did.
Are you step in front of the microphone so that we can hear you?
I did.
Has anyone promised you anything other than what was stated here in open court?
No.
Anyone threatened or coerced you in any way to get you to enter this plea?
No.
You satisfied with the advice of counsel?
Yes.
Need additional time to speak with counsel?
No.
You waiving your right to a trial by jury? You waiving your right to appeal anything other than a legal sentence?
Yes.
Are you under the influence of any alcohol, drugs, or medication?
No.
I have to advise you, if you're not a U.S. citizen, by entering this plea, it could subject you to deportation. Counsel, anyone aware of any exculpatory DNA in this case?
No,
Ms.
Your Honor.
McMillan? And how old are you, ma'am?
25,
And your highest level of education?
graduate,
High school, college?
high school.
Have any questions? Is this how you want to resolve your case? All right, ma'am, I'm going to find your plea in 25 CF 55, knowing, intelligent, and voluntary. I reviewed the complaint affidavit. I'm going to find there is a factual basis. You'll be adjudicated guilty of all 3 counts. On counts 2 and 3, which are misdemeanors, you'll be sentenced to time served. On count 1, you'll be sentenced to 48 months probation. You must perform 100 hours of public service work. The cost of supervision is $20 per month. Within 30 days of today, you must enroll in a drug and alcohol evaluation and follow up with any counseling. The Department of Highway Safety and Motor Vehicles may apply additional penalties. You must provide a DNA sample, forfeit seized items. You have court costs and fines in the amount of $1,008. And counsel, you waive my reading of the discretionary costs and fines.
Yes, Your Honor.
And Ms. Henson, do you have any questions about the court costs and fines, ma'am?
Yes.
Have you reviewed the court costs and fine sheet?
I have not received it, then no,
Okay, you want to review it?
I would like to.
Okay,
May I approach?
you may.
So I can surrender.
Have any questions about the court costs and fines imposed, ma'am?
No.
All right. Got 30 days from today to appeal the judgment and sentence of the court. If you cannot afford an attorney, one will be provided for you. Best of luck to you, Ms. Henson. Thank you, Mr.
Thank you, Your
McMillan.
Honor. That's all I have before the court. May I be excused?
Certainly. Take care, sir.
Thank you.
Mr. Peters?
Afternoon, Judge. I have one case, Twyla Tiller.
Okay. Where are we at on Ms. Tiller's case? I believe she was, last time we were here, the parties agreed that she was not guilty by reason NGI. Was it NGI or, okay.
I'm not guilty.
Do-
And you had mentioned a follow-up care plan, and we looked into the statute and the rule on that. And I think there may be some more factual findings under 394 before we can enter into that sort of involuntary outpatient type thing. So that's where we are.
All right, have I received a plan or?
Well, I'm thinking that maybe there needs to be the 2 reports by the psychologist didn't exactly meet the criteria that are required under 394. So
Okay.
I think we should probably maybe review those facts, requirements under 394 and see if you want to order that involuntarily. You want to, I mean, so 394.467 talks about involuntary inpatient placement. And I think under criteria for involuntary services, subsection 2, it appears that you got to meet all of those requirements, 1 through 6. I'm not sure that the reports exactly address that. Ms. Tiller is actually taking her medicine and living and following, basically doing that voluntarily. So the question then becomes whether or not we enter a court order And in order to enter that court order under 394.467, I think we got to meet the evidentiary requirements of 394.467(2), and there were various provisions in that.
What I was going to do, my plan was conditional release in lieu of involuntary placement under 9/16/17, and just have a plan for outpatient treatment. The statute that I was traveling under was 9/16.17, and I was going to order the conditional release, which I've already ordered, in lieu of any involuntary commitment, and have a written plan for outpatient treatment, including recommendations from qualified professionals, which those two reports, I believe, satisfy that requirement.
Is that a conditional release prior to the finding?
What I'm reading says, except for an inmate currently serving a prison sentence, the committing court may order a conditional release of any defendant in lieu of an involuntary commitment to a facility based on an approved plan for providing appropriate outpatient care. And I believe there is also a Rule 3.219 that I mentioned. And it was simply just going to be a conditional release of Ms. Tiller with a plan a written plan that she has to comply with treatment. And if that plan is that she continue to comply with her medication regimen and see any treatment professional that she's currently seeing, of course, we'll run it. You can run it by Mr. Patterson, and if that's the plan, that's the plan.
I guess that would put her under some kind of conditional release officer.
Yes, sir.
Buddy?
No, not conditional release officer. She'll just be in the community on conditional release, and the terms will be that she comply with that written plan. And of course, the condition is that she doesn't violate the law, and we'll come back ever so often just to ensure that she's complying with the plan.
All right, so the conditions of her release that you want to include are that she take her prescribed medication, that you follow up with the doctors, that kind of thing?
Yes, sir. I do not recall what was in the doctor's report, what they requested or said would be appropriate. But the written plan was going to be consistent with those two reports from the experts. But outpatient mental health services comply with her medication regimen.
Okay, maybe we should schedule this for another month, and then we'll send you a proposed order and council a proposed order that everybody can sign off on.
Yes, sir. You want to come back in August? Give you some time to get that done?
Yes, sir. Thank you.
All right, Mr. Patterson, any objection? All right, that'll be August 12th at 1:30.
Okay. Thank you, Judge.
All right, thank you, Mr. Peters. Anything else on today's docket?
No, Your Honor, appreciate it. Thank you very much.
All right, thank you. Mr. Dogle?
Good afternoon, Your Honor.
Hey, good afternoon.
I have Robert Q on the docket, and I don't know if he may be in custody, Judge. He called my office a little over an hour ago.
What's that last name?
Q, C-U-E.
Number 10 on page 3.
Okay. Mr. Q, you with us? Oh, come on down. All right, here we are. Here's Mr. Q, Mr. Dogle.
And Judge, the reason he's now in custody is apparently they came to serve a warrant. I don't have any copies of anything, but they were saying that he failed to register, and our understanding was it was a boat trailer, which I don't believe would be required because you're not living on a boat trailer to register that per the statute. So what I would ask the court is if Your Honor would consider first appearing him at this time and setting a bond so we can straighten that out. I've also sent some emails to Mr. Patterson about resolving this case. This is a case I'd taken over from Mr. Bollinger.
I don't see a warrant.
Yeah, they just arrested him probably, Mr. Q, what time was it? About 11 o'clock when you called me?
Yes, sir, 11 o'clock.
Yeah, I don't have anything in front of me, Mr. Dogle, about the new case.
Sir,
Yes, sir, Mr. Q.
I have sold the boat 8 months ago, the boat and everything. I don't
Okay.
even own a boat.
Yeah, I don't have anything in front of me to first, I don't know what you're talking about. I don't have I'm not sure if it was a warrant. I don't have anything, so he'll have to go first appearance tomorrow morning before Judge McFarland.
Okay. I just didn't know if the court had it and if it could be addressed at this time. So,
Yeah, if I had it, I wouldn't mind, but I don't have anything in front of me. I simply see the case he's before me today on.
Mr. Dogle, can you hear me, sir?
This is Mr. Hill, Mr. Dogle.
yeah, I can hear you, Brian.
All right, we do those at 8:45 Eastern time every day over here. So if you wanna jump on Zoom in the morning and take care of the first appearance, it'll be at 8:45 in the morning.
Eastern time, correct?
Yes, sir.
Okay. Yeah, I'll get the Zoom number and jump on.
Yeah, I just checked our circuit. I'm not even sure if it's been processed yet. I don't have anything with Mr. Q with the pending arrest warrant in the entire circuit, so not sure where that comes from.
I was told they arrested several this morning before lunch, Judge, so.
Okay. Allegedly, I guess the sheriff's department or police department arrested several people before lunch. And I assume it was not on an arrest warrant, because if so, I will have it before me or be able to look it up. And I don't see an arrest warrant for Robert Q anywhere.
Okay.
So whatever it is, he'll be be brought before Judge McFarland tomorrow morning at 8:45 Eastern, and you can address it at that time. On this case, Mr. Dogle, you want to come back next month? See if you all can work it out?
Yeah, I've tried. I don't know. At this point, I've sent some emails.
Mr. Patterson?
Mr. Patterson's not received them or not.
Judge, if we could, let's set it for 7/8, and see if we can at least figure out what's going on.
Okay. All right, Mr. Q, we'll see you July 8th at 1:30.
Thank you.
Oh, thank you. But he'll
Thank
get
you,
a bond on, he'll get a bond on the new case.
Okay. Is
Mr.
the
Morris?
I get Judge, let me
Yes,
ask
sir.
this question. Knowing that there's the new part, is the court wanting to revoke his bond? I mean, because you'd be the judge that would be controlling that portion.
Yeah, there's no motion to revoke his bond, and I don't know the basis of his new arrest. So I'm not going to revoke his bond at this time. If there's a motion, I'll consider it. But without the basis for his new arrest, I'm not going to revoke his bond.
Because I just didn't want to misrepresent something to Judge McFarland tomorrow morning.
Yeah, I'm not addressing his bond status on the pending case.
Okay.
Of course, if Mr. Patterson raises that issue tomorrow morning, but I don't know the basis of his new arrest.
Okay.
But we do have court on Thursday. If anything comes up out of the unusual and you need to bring him back before me, we'll be back here on Thursday.
Okay. Thank you, Your Honor.
All right, thank you, Mr. Dogle. Mr. Morris?
Good afternoon, Judge. Dana Morris on behalf of Latoya Nelson. That's case number 22118 CF. You'll recall, Judge, that she has been undergoing competency restoration services for some time now. The court had found her incompetent back on November 4th of 2022. She's undergone 26 months of restoration services. I filed recently a motion to dismiss the case without prejudice to the state. That hearing has been set for July 10th. And that's pretty much where we are with the case, Judge.
Okay, thank you, Mr. Morris. And I'll see you all on July 10th for the motion hearing.
Yes, sir.
All right, thank you.
Thank you.
Ms. Bennett?
Yes, good afternoon, Judge. How are you doing?
I'm well. How are you doing, ma'am?
I'm doing well, thank you. I'm here for Matthew McGinnis. This is case number 25025. I don't know if Mr. McGinnis is in the courtroom.
Yes, come on up, Mr. McGinnis.
And in Mr. McGinnis' case, we have just received the discovery for his case. What we have not is proper contact information for Mr. McGinnis. We sent him 2 letters and have not heard anything back from him. I do not have a phone number, email address, or anything to that effect to reach him.
Just got a letter in the mail 2 days ago. I haven't seen the second one yet. But I did finally receive a letter though.
Have you reached out to your attorney, Mr. McGinnis?
No, not yet.
When do you plan to call Ms. Bennett?
Today.
You have Ms. Bennett's phone number, office number?
I believe I have a card.
You have her card?
I believe so, yes, sir.
All right, other than the communication issue, anything else we need to discuss on this case today?
Like I said, we've just gotten the discovery. Once we have Mr. McGinnis's contact information, we'll make sure to share it with him and go from there.
Okay, so what we'll do, 2 things. First, we'll come back August 12th at 1:30 for a pretrial conference. And Mr. McGinnis, I'm going to order that you contact your attorney's office today, okay? I'm going to include a note in your case file, and I'll inquire about that at our next court date. If you haven't contacted your attorney, I may revoke your bond. You understand that, sir?
Yes, sir.
Okay.
Can I put a second number too, just in case?
And Ms. Bennett, Mr. McGinnis said he'll give you a call this afternoon. Call your office.
That sounds good. That's all I have, Mayor.
Certainly, Ms. Bennett, take care and good to see you.
Likewise, thank you.
Ms. Anderson, how are you doing, ma'am?
I'm good, sir. How are you?
I'm doing good. Who we have this afternoon?
We have Joseph Peters, case number 24-106. I spoke
Okay.
with Mr. Patterson last week and got we were doing some coordination on where we think this case is going. I think that we're going to have to do some depositions. Apparently none of those have been done previously. If we could go to the July date, I'd like to, I hope to have maybe some depositions scheduled by then.
Okay, that's July 8th at 1:30.
I would suggest
Yes.
August 12th. If we're gonna schedule depots. There's no way we're gonna have depots by July 8th.
Okay, and we'll go to August.
Okay, that's August 12th at 1:30.
Yes, sir.
Anyone else, Ms. Anderson?
No, sir, that's all I have.
All right, good to see you and take care, ma'am.
You too, sir. Bye-bye.
One moment, Ms. Anderson.
No, Ms. Anderson can go.
Oh, okay.
I was gonna usurp Mr. Lease. I'm gonna make Mr. Lease's day, Your Honor.
All right, Mr. Lees.
Your Honor,
Good afternoon,
Judge. Case number 2453, State of Florida versus Quinlan Rhodes. I've been in contact with the United States Attorney's Office in Pensacola. He has been indicted federally on these same facts and charges, and at this time I'll announce an all process.
And the case is dismissed.
That was an easy day. Y'all have a good afternoon, Judge.
You as well, sir.
Thank you.
Ms. Peskin, you ready, ma'am? Okay. Joseph Atkinson.
Judge, on Mr. Atkinson's case, I would move to go ahead and set him on the trial management docket in September and the September jury trial docket.
All right, any objection?
No, Your Honor.
All right, that trial management will be September 11th at 9:30 and jury trial September 29th. Rodney Atkinson.
This was Mr. Atkinson. We were appointed on 5/27, but this is his first pretrial conference since that appointment. We had mailed out, I guess, the information, and I assume we did not realize he was in custody because I just have no notes on that. But if we could pass it to the pretrial conference the next month or whenever this court feels is appropriate, I can make that appointment to see him.
Why is he in custody? Looks like he's a level 1 driving charge.
That
Can he not make the bond or something? Or is he being held on something else?
I'm on child support too right now.
Oh, okay. He's been held on child support. All right, we'll see you July 8th at 1:30.
Sorry about that. We thought you were out. Thank you.
Edith Ash.
Judge, before you is Edith Ash, case number 2523 CF. And at this time, Ms. Ash will change her not guilty plea to a plea of no contest to both counts. Count 1, possession of a controlled substance, 3rd-degree felony. Count 2, possession of drug paraphernalia, a misdemeanor. In exchange for that plea, we're asking the court to adjudicate her to be guilty, place her on drug offender probation for a period of 30 months, and that does include the 7 p.m. curfew. We're going to ask the court to allow probation to modify that curfew for her work schedule. In addition, she will be ordered to pay the court cost and fines. Cost of supervision is going to be $20 per month, 100 public service work hours. Those may be converted to a financial obligation at the rate of $10 per hour. There will be a substance abuse evaluation, and following your recommendations, she must enroll within 30 days of today. There will be a random year analysis. The first one within 30 days will serve as a baseline. The Department of Highway Safety Motor Vehicles may apply penalties to her driver's license. As to the misdemeanor, it'll be time served. We're stipulating there's a factual basis for the purpose of the plea, and she'll be required to submit to a DNA buccal swab if necessary. Sound right?
Ms. Ash, you'll raise your right hand for us. You're Miss Edith Ash.
Yes,
How old are you and what's your highest level of education?
40 high school.
Did you hear Mr. Hill's announcement about how we're going to resolve your case?
Yes,
Is this how you want to resolve your case, ma'am?
yes,
You understand you're waiving your right to a trial by jury and waiving your right to appeal anything other than the legal sentence?
yes, sir.
You satisfied with Mr. Hill's services?
Yes,
Are you under the influence of any alcohol, drugs, or medication?
no,
You understand if you're not a U.S. citizen by entering this plea, could subject you to deportation?
yes,
And counsel waive any exculpatory DNA?
No, sir, Judge.
Mr. Patterson, in this case, no exculpatory DNA. All right, Ms. Ash, I reviewed the information and complaint affidavit. We're going to find there's a factual basis. You'll be adjudicated guilty of counts 1 and 2. On count 2, you'll be sentenced to time served. On count 1, you'll be sentenced to 30 months of drug offender probation. That includes the 7 p.m. to 7 a.m. curfew, which can be modified at the discretion of probation for work purposes. The cost of supervision is $20 per month. You have fines of $1,005. And have you reviewed the court cost and fines sheet, ma'am? You okay with my not reading the discretionary costs and fines?
Yes, sir.
You must perform 100 hours of public service work. Your public service work hours may be converted to a financial obligation at $10 per hour within 30 days of today. You must enroll in the substance abuse evaluation and follow up with any recommended counseling. You'll be subjected to random year analysis, but your first year analysis within 30 days will serve as a baseline. The Department of Highway Safety and Motor Vehicles may apply additional penalties, and you must provide a DNA sample. You have any questions, ma'am? You have 30 days from today to appeal the judgment and sentence of the court. If you cannot afford an attorney, one will be provided for you. Best of luck to you. William Blackman.
Judge, on Mr. Blackman's case, I would ask that we reschedule continue the pretrial to the August pretrial date. I need some more time to work with Mr. Blackman as well as Mr. Patterson on a resolution for this case.
Mr. Blackman will see you August 12th at 1:30.
Yes, sir. I'm gonna sign a notice and then.
Wayner Bravo.
you're free to go. Yeah. Judge, on Mr. Bravo's case, I forgot to tell Miss Judy that we needed an interpreter. So we may need to bring him back Thursday and I'll let her know so we can get Mr. Ricardo on board because he understands a little bit of English, but he doesn't understand enough to conduct anything significant with his case.
Okay, we'll bring you back on Thursday, Mr. Bravo. Jueves.
Miss Judy, can you hear me?
Yes, sir.
Can you make a note that we'll need an interpreter for Thursday's docket so that we can take care of Mr. Bravo?
Yes, sir. I sure will.
Thank you, Miss Judy.
Yes, sir.
So on the front row, are you okay? I saw that you dozed off and heard you snoring. You okay? What's your name? Moser? Come on up, Mr. Moser. I don't want to bore you, so we'll go ahead and call your case.
Judge, on Mr. Moser's case, after consulting with him and considering the nature of the case, after I talked to Mr. Patterson has agreed to reinstate Mr. Moser on the PTI program. There's some underlying factual issues with this case, and we believe it's appropriate for him to go back on PTI.
All right, Mr. Moser, best of luck to you. States agreed to put you back on the pretrial intervention program. We'll take you off the docket.
Yes, sir. You need to check in with these folks right here and find out when you need to report back into them, okay? Yes, sir.
We handled Ryan Carver this morning, correct?
We did, Judge.
All right, Jason Cotret.
There he is. We had met, Mr. Cotret and I had a phone conference last time. We had tried some negotiation with the state that hasn't reached a resolution. So at this point, I think if we wanted to set him for trial management, wherever the court thought was necessary, and Mr. Cotret can make a new appointment to speak with me, and so we can prepare for that.
All right, Mr. Cotret, we'll place you on our September jury trial docket. So your trial management will be September 11th. Jury selection will be September 29th.
Yes, sir.
Okay, and just make that a new appointment, please. And then
Barbara Dasher.
Judge, I've met with Ms. Dasher on her case, and we're still in the process of trying to negotiate a resolution. If we could have one more pretrial and give us some more time to work on some mitigation and things of that nature, I believe we'll be in a posture to resolve it by then.
All right, Ms. Dasher, we'll see you August 12th at 1:30, ma'am.
Yes, sir.
You're
Thank
gonna
you.
sign a notice.
Shedrick Falk.
Judge, this is Cedric Falk before you, case number 2268 CF. At this time, Mr. Falk is going to withdraw his denial, enter an admission to violating the terms of his probation as filed in affidavits filed on 1/24 of 25 and 3/25 of 25. There's no agreement as to sentencing. He's entering this admission with the understanding that I'm going to present the probation officer's recommendation as to sentencing. Is that correct, Mr. Falk?
Yes, sir.
All right, we'll sign right there.
All right, Mr. Falk, you raise your right hand for me.
Yes, ma'am.
Mr. Falk, you tell me your name, your age, and your highest level of education.
Chevy, 47, GED.
And Mr. Falk, Mr. Hill tells me that you wish to withdraw your denial and admit you violated your probation.
Yes, sir.
Is that your decision?
Yes, sir.
You doing so on your own free will?
Yes, sir.
Anyone threaten, promise you anything?
No, sir.
Anyone coerce you?
Yes, sir.
You satisfied with Mr. Hill's services?
Yes, sir.
You need additional time to speak with Mr. Hill?
Yes, sir.
You understand you're waiving your right to an evidentiary here?
Yes, sir.
Are you under the influence of any alcohol, drugs, or medication?
No, sir.
I'm going to accept your admission as known, intelligent, and voluntarily entered into, Mr. Falk, as far as sentencing. Mr. Hill?
Yes, sir, Judge. At this time, I would present the probation officer's recommendation, and that is that Mr. Falk be placed on community control 2 for a period of 6 months to be followed by the balance on drug offender probation. Also, the recommendation is that he complete a substance abuse evaluation within 30 days and comply with any and all recommended treatments, as well as take a driving on a suspended license, suspended counsel or revoke course. And any condition that had previously been ordered that hadn't been completed, obviously that would need to be completed before the end of his term.
All right, is this was that the recommendation consistent with the sentencing guidelines? No? Okay. Go ahead, Mr. Patterson.
Your Honor, the sentencing guidelines call for Mr. Falk to, at a minimum, he scores 29.1 months in the Department of Corrections. However, Mr. Falk entered a open plea on 6/23 of 23 and was given a 14-month suspended sentence. So as it stands now, that is the maximum that he can receive from court.
And Mr. Falk, did you hear that?
Yes, sir.
And were you aware of that when you decided to withdraw your denial?
No, sir.
You were not? Do you? Let me ask you. Well, I know you were aware of the suspended sentence because I sentenced you and
Right.
you said you wanted to do that.
I've discussed it with him as well, Judge.
And Mr. Hill discussed it with you. Unless there's some basis not to impose the suspended sentence. And that's what you agreed to. You want to withdraw your admission? Or you want to move forward?
Judge, what I've explained to him is obviously that his sentence is capped at 13 months. That's the maximum, even though he's got, because of the suspended sentence, he told me he wanted to enter open admission and present the officer's recommendation. I told him I would do so. He understands, and it's my feeling and my belief that he understands he has a right to go to an evidentiary hearing. I don't know that I know that Mr. Falk is not going to be successful at an evidentiary hearing. So it's either, I mean, this is basically where he's at with the options that he has. I mean, they're pretty limited, unfortunately, with being a violation of probation.
All right, Mr. Falk, the minimum under the guidelines is 29 months. The suspended sentence was 14 months. So under the law, I'm capped at 14 months. The probation officer's recommendation is not a basis, I mean, for me to continue to downward depart from anything. I mean, what's the VOP? What is that? How many points? Actually, I can probably look at your score sheet.
It's adding.
Yeah, 6 points to a judge. It was a positive UA, and then he got a new driving on suspended license charge over in Bay County. So it's got a total of 6 points were added to the violation for the thing, and the basis for Mr. Falk's.
Your Honor, the score sheet, it does have an error on it. It would, the absent the suspended sentence, the minimum would be 24.6.
And another reason for Mr. Falk's request, Judge, is he suffers from sickle cell, and since this violation came about, he's been in the hospital several different times. Obviously, since I met with him last time, and today he's obviously been back in the hospital a couple of times, and the last time he come out, he's on oxygen, as we can see today. And that was another reason Mr. Falk wanted me to present to you the recommendation of the probation officer. Is there anything else you want the judge to consider, Mr. Falk?
Mr. Patterson, anything else?
No, Your Honor.
All right, Mr. Falk, in 22 CF 68, you'll be, if you were not previously adjudicated guilty, you'll be adjudicated guilty. Your probation will be revoked. You'll be sentenced to 1 year, 1 day in the Florida Department of Corrections. You'll be given credit for the time you've served. You have an additional $250 violation of probation fee that will be reduced to a civil judgment. I understand the medical condition. I'm willing to give you some time to report. Yes, ma'am. Someone raised his hand. Come on up, ma'am.
My name's Patricia Richardson.
Yes, ma'am, come on up.
I'm Shad's aunt.
Yes, ma'am.
Shad's gonna have a heart procedure Monday. He's really a sick guy, and I know he's been in a lot of trouble. And we just asked leniency for him because he's really sick. He don't understand a lot of stuff you're saying either. I'm sorry that he won't say that, but he doesn't. He's a real sick man. His heart is, it's not good. So Monday they're gonna go in and try to put some in. He suffers with sickle cell. He has a disease. I'm so sorry he's here on all of these conditions, and he hasn't been doing the right thing, but he realizes now that he's a sick man. He won't make it. If he goes to prison, he won't make it.
You say you have a procedure Monday?
Yes, sir.
Yeah, I'll give him an opportunity to take care of his medical and report on another day. That's perfectly fine with me. Mr. Falk, when you came before me before, you agreed to 14 months. You violated your probation. In fact, the 14 months is less than the minimum. The minimum will be 24 months, but I'm capped at 14. I sentenced you to less than 14 months. I basically gave you a year and a day with whatever credit you have. So, but if you have a heart procedure scheduled for Monday, I'll give you an opportunity to go take care of your surgical and medical procedures and give you a date and time to turn yourself in. What date and time do you want?
Procedure Monday in Gainesville, University of Florida.
Okay.
And I got a follow-up on the 16th of July.
You said a follow-up when?
The 16th of July. I can have all the paperwork sent to Mr. Patterson.
Okay.
I mean, Mr.
Hill?
Mr. Hill and Mr. Patterson if you need it.
Okay. Yeah, if you'll just send your paperwork to Mr. Hill. So what day do you want to turn yourself in?
Our court dates are gonna be.
The next court date, I mean, August. I should be through with everything because I got a follow-up on the 16th of July.
Okay.
After the procedure.
That's fine with me. August 12th, come back for a pretrial conference and you'll go into custody at that time. Give you some time to take care of your business and have your medical procedure, all right?
Thank you.
Thank you, sir.
Now, Mr. Falk, don't let me have the sheriff's department go out looking for you now.
You won't.
All right? We'll see you on the 12th. Yes. Sir. Kenneth Fisher Jr.
Judge, on Mr. Fisher's case 2515, I'd request a continuance of the pretrial to 8/12. I've met with Mr. Fisher and there are some witnesses that I need to investigate for potential defense on his behalf. So just need some more time on this case.
All right, Mr. Fisher, how you doing?
I'm doing well.
All right, good to see you, sir. We'll see you on August 12th at 1:30.
Yes, sir.
Charles Gamblin.
Judge, on Mr. Gamblin's case is 2516. Mr. Patterson and I have been discussing this case and the basis for the traffic stop. Concluded it's necessary to file a motion to suppress and have you give us a ruling on the issue in this case. So if we can set this for 8/12, I will go ahead and get I'll go ahead and get the motion filed. I'll tell you what.
Want to put it on the motion docket
I've been
for
8/14. Let's go ahead and put it on the motion hearing docket for 8/14 because I'll get the motion filed and we can go ahead and get that done without delay.
All right, we'll see you August 14th at 9:30 for a motion hearing.
Thank you. You got to sign that notice, sir.
Joseph Garner.
Judge, on Mr. Garner's case, I think we're pretty close to reaching a resolution on this one. If we can, just bring him back on that July 8th pretrial date. And I know we're getting some age on us. If we don't have it resolved by that date, I will ask that we set it on the trial docket.
Yes, sir. Mr. Garner, we'll see you July 8th at 1:30. Michael Gloner.
Morning, or good afternoon, I
Good
guess.
afternoon, Ms. Miller.
It's, we're here on Mr. Glover. He's here in 2574. We were appointed on May 6th. We did receive some new discovery. It was like it was from an FDLE related discovery on 527. We had mailed the materials to the client. We believed he was out of custody. Those came back to us just on 6/12, and that's when Cindy remailed those materials to him at the jail. If we could pass Mr. Gloner until the next pretrial so that we can make that meeting to discuss what we've remailed to him. That would be great.
Was he out of custody and then remanded, Mr. Gloner?
I was housed in Franklin County Jail.
Okay. All right, so we'll come back July 8th at 1:30. That's our next pretrial conference. Give Ms. Miller an opportunity to give you discovery. You all can review it and we'll see where we are at that court date.
Thank you, Your Honor.
Mr. Stanley Gray. Mr. Gray, how you doing?
How you doing, Your Honor? I turned myself in, Your Honor. I was a day late, I'm sorry.
Yes, sir.
Judge, Mr. Gray's here. It's a violation of probation. There's previously ordered suspended sentence. He's set for evidentiary hearing on Thursday of this week, and I just asked it to remain there. We'll get this resolved with a hearing.
All right, Mr. Gray, we'll see you Thursday at 9:30.
Yes, sir. Thank you, Your Honor.
Ms. Peskin, you ready, ma'am? Ms. Peskin, Ms. McGee, you ready?
I am, Your Honor. I have Thomas Moore.
Thank you, ma'am.
We're in the middle of coordinating depositions with the Public Defender's Office. It's taken a little bit of time. So I'd ask for the August date, Your Honor.
Okay. Thomas Moore.
Yes, sir.
One moment.
Okay.
Looks like the docket maybe has a fence date 12/3/2002. You don't even look like you're even born at that time.
I
So,
don't think that's right.
I'm a little older, Your Honor.
okay. It's a 2025 case.
I believe it is, Your Honor. Either that or late 24.
Okay, several.
He
Perfect.
does.
December 4th, 2024. Got it. All right, when do you want to return?
August?
Okay, we'll bring you back, Mr. Moore, August 12th at 1:30 for a pretrial conference that'll give your attorney some opportunity to schedule and possibly take some depositions.
Wonderful, thank you. Dr. Discovery, can you do that? Thank you.
Timothy Gray? Mr. Gray, good to see you.
Judge, based on the age of this case, I know I had the case at one time, then Mr. Gray pursued private counsel and the case was recently returned back to my docket. So I'm very familiar with the facts and the evidence of the case. And due to the age, I would ask we go ahead and put this on the trial management and the jury trial in September. If we're able to get it resolved, that's great. But if we're not, we can go ahead and get some closure to it since it is a 2023 case.
Yes, sir. Mr. Gray, we'll see you September 11th for trial management and September 29th for jury selection. Wade Hackney.
I have Wade Hackney before you, 2567 CF. At this time, Mr. Hackney is going to withdraw his not guilty plea, change that to no contest to the count 1 possession of a controlled substance, 3rd degree felony, In exchange for his plea, the agreement is for the court to withhold adjudication, place him on 24 months of drug offender probation with the curfew. Court costs and fines are assessed at $1,005. Will waive individual reading of the court cost, fines, and fees. Cost of supervision is assessed at $20 per month. 100 public service work hours. Those may be converted to a financial obligation at the rate of $10 per hour. There will be a substance abuse evaluation and follow any recommendations. He must enroll within 30 days of today and complete any recommended treatment on the first attempt. Department of Highway Safety Motor Vehicles may apply penalties to his license that will stipulate there's a factual basis for the plea and submit to a DNA sample if necessary pursuant to law. Sign right there.
Mr. Hackney, you raise your right hand for me, sir. Sir, would you tell me your name, age, and your highest level of education?
Wade Hackney, GED, 49 years old.
Did you hear Mr. Hill's announcement about how you're going to resolve your case? Is that consistent with your understanding?
Yes, sir.
Anyone promise you, threaten you in any way to get you to enter this plea? Have you had a sufficient amount of time to speak with Mr. Hill?
Yes, sir.
Are you satisfied with the services?
Yes, sir.
Are you understand you're waiving your right to a trial by jury and you're waiving your right to appeal anything other than an illegal sentence?
Yes, sir.
Are you under the influence of any alcohol, drugs, or medication?
No, sir.
Looks like I have two plea forms. I must advise you, Mr. Hackney, that if you're not a U.S. citizen by entering this plea, it could subject you to deportation. And essentially, you're going to be on probation for 2 years, have court costs and fines, be on drug offender probation with the curfew, and take a substance abuse evaluation and follow up with any recommendations, correct? All right, so I'm going to accept your plea as known, intelligent, and voluntarily entered into in 25 CF 67 for possession of methamphetamine. Adjudication will be withheld. You have court costs and fines in the amount of $1,005. Mr. Hill, you waive my reading of discretionary costs and fines.
I do, Judge.
Mr. Hackney, sir, this will be drug offender probation with the 7 p.m. to 7 a.m. curfew. You must perform 100 hours of public service work. Your cost of supervision is $20 per month. Within 30 days of today, you must enroll in substance abuse evaluation and follow any recommended counseling. The Department of Highway Safety and Motor Vehicles may apply additional penalties. You will be subjected to random year analysis. Your first year analysis within 30 days will serve as a baseline, and you must provide a DNA sample. You have any questions for me, sir?
Judge, one thing we did, I didn't hear you say it, but part of the agreement was that as for the counseling, if there's any recommended, he must complete that on the first attempt.
And for any recommended counseling, Mr. Hackney, you must complete that recommended treatment on the first attempt. Okay, sir, you got 30 days from today to appeal my judgment and sentence, and if you cannot afford an attorney, we'll provide one for you. Best of luck to you. Bradley Hall. Kashina Harper. Come on up, Ms. Harper.
Judge, on Ms. Harper's case, I will move to continue her pretrial conference to August the 12th. I have had a phone conference with Ms. Harper, but I need a in-person meeting with her so we can go over a few things. And I think it's a case we can get resolved, but I would feel more comfortable having an in-person meeting with her to address some of the issues that have come up since we talked on the phone last time.
Absolutely. Motion to continue. Granted, Ms. Harper will see August 12th at 1:30. Just schedule an appointment with Mr. Hill before then, ma'am.
All right, sign that there.
Devon Harrison.
I'm on, since you live in Grand Ridge, we're working, try to get something up there in Jackson County, maybe, so you have a problem coming to see me, that I can go see you.
Thank you.
Good afternoon.
Hey, Mr. Harrison, good afternoon.
Judge, on Mr. Harrison's case, I had an office appointment scheduled with him and he didn't keep it. And it's my understanding from what I was told earlier that he was trying to retain private counsel, but then that fell through as well. So the reason he didn't keep his appointment with me is he was trying to get another attorney. So I've not met with Mr. Harrison. And if he wants to continue with my representation, I'll need to continue the pretrial and set up another office appointment with him.
Mr. Harrison, you're gonna continue with Mr. Hill or you're gonna hire an attorney?
Yes, I'm gonna continue, Mr. Hill.
Okay, when do we want to return, July or August?
August 12th, Judge.
All right, Mr. Harrison, we'll bring you back August 12th at 1:30. That'll give you an opportunity to meet with Mr. Hill, review your discovery and see if we can resolve this case.
Okay. Also, Your Honor, I live in Jacksonville. Is there any way that I can do that
If
via
you'll,
Zoom?
if you'll meet with me and we can discuss your case after that, I can file a motion to ask the court to allow you to appear by Zoom, but I need you to meet with me first.
Yes, sir.
Demonte Haddix.
Thank you.
Judge, on Mr. Haddix's case, there's a motion to compel pending. It's set for hearing on Thursday of this week. So Mr. Haddix and I have gone over the evidence. There's still some stuff that we're waiting on from out of state. So I would ask that we just put this on the docket for 7/8. And that way we can update the court on, I don't think the state's gonna have an objection to the motion to compel because it appears to be stuff that's relevant, but I would rather put this on the docket for 7/8. That way we can update you on whether or not we have, where we are with our discovery obligations, and whether they're complete or other things need to be addressed.
Have you reviewed the motion to compel, Mr. Patterson?
I have, Your Honor. It's items that are not in our possession. They're in the possession of a law enforcement agency in Georgia. So we have been trying to jump through the hoops and decipher which agency and even potentially which unit at that agency actually has these items. So
Okay.
efforts have been made since the motion was filed to locate it, but we have not gotten our hands on it as of yet.
So we'll return July 8th.
I would ask that we come back July 8th, Judge. That way we can let you know where we are. If we're close, if we have this stuff, if we're close to getting it, because based on my review of the evidence and discussing with Mr. Haddix, I believe this stuff is very material and is very much relevant to for us to investigate this case thoroughly, because what we're dealing with is the Georgia Department of Probation or Community Services, as well as GBI. They are the ones that they did a search in this case. They arrested Mr. Haddix and they recovered property allegedly from Mr. Haddix that was turned over to local authorities. And we have no reports or nothing. We have nothing from Georgia as far as reports or anything of that nature as to who was involved, any statements that were made. So, I think it's very much material and relevant.
All right. We'll see you on July 8th, Mr. Haddix, and we'll see the state and your attorney will try to see if they can get that information from the state of Georgia, okay? All right, thank you. Heather Honaker or Honaker?
Judge, on Ms. Honaker's case, we have a plea agreement worked out, except for the issue of restitution. We're a good bit away on what we think the restitution would be. I would ask that we bring Ms. Honaker back on 7/8, and that should give us enough. Mr. Patterson was gonna make some phone calls and see if we could get that restitution issue resolved. And I think 7/8 will give us plenty of time to get that done.
We'll see you July 8th at 1:30.
Yes, sir.
Right here.
Johnny Hurley?
Thank you.
Judge, on Mr. Hurley's case, he is going to, in case 2447, he will withdraw his denial, change that to an admission that he violated the terms of his supervision in the affidavit filed on December the 20th of 2024. In exchange for his admission, he has agreed with the state that his supervision is to be revoked. He'll be sentenced to 18 months in the Department of Corrections, awarded jail credit for 424 days, $250 VOP court cost will be assessed. That, as well as any other outstanding monetary obligations, are going to be reduced down to a civil judgment. Sign right there. And Judge, while Mr. Hurley is signing this form, I would ask that the court make a recommendation that Mr. Hurley be housed in a facility separate from Mr. William Raker. Mr. William Raker is the father of the alleged victim in this case, and these two do not need to be in the same facility. I don't, based on the timing, I don't know that Mr. Hurley will ever leave the reception center. He's only going to have a few months left to serve on this sentence, but in the event he does, we would ask the department keep them separate.
Okay.
Two things, Your Honor. One, the victim in the case has been notified and is in agreement with this resolution, the parent of the victim. And the Mr. Raker, to the best of my knowledge, and I can tell right now, is currently housed at the Holmes County Work Camp.
Mr. Hurley, you raise your right hand for me.
Yes, ma'am.
Mr. Hurley, you admit you violated your probation?
Yes, sir.
Anyone promise, threaten, or coercion in any way to get you to admit you violated your probation?
No, sir.
You're doing so on your own free will? You
Yes,
understand you're waiving your right to an evidentiary hearing?
Yes, sir.
You satisfied with Mr. Hill's services?
Yes, sir.
Have you had a sufficient amount of time to speak with Mr. Hill?
Yes, sir.
And are you under the influence of any alcohol, drugs, or medication?
No, sir.
All right, Mr. Hurley, in 24 CF 47, I'm going to find that your admission is knowing, intelligent, and voluntary. I'm going to revoke your probation. You'll be sentenced to 18 months in the Florida Department of Corrections. You have jail credit for 424 days. Have you reviewed that jail credit?
Yes, sir. I'm pretty sure it's 426. I think. Pretty sure.
I can verify that, Judge. I tried to calculate the time that he was in before and the time he's in now, but I mean, I'll go back and review my calculations,
Okay.
and if I miss 2 days, I'll let Ms.
It
Knox.
may be. It's not that serious. It may be though. Yeah.
All right, we'll confirm that it's 424 days. If you're entitled to 2 additional days, we'll give you that credit. You have an additional $250 violation of probation court costs. That fee, along with any outstanding monetary obligations, will be reduced to a civil judgment. I'm going to recommend that you be housed separately from William Raker, and at this time not be housed at the Holmes County Work Camp. Got any questions for me?
No, sir.
You got 30 days from today to appeal the judgment and sentence of the court. If you cannot afford an attorney, one will be provided for you. Best of luck to you, sir.
Thank you.
To see the
Jeffrey Jackson?
Your Honor,
Yes, sir.
in case number 2491 CF and case number 2492 CF, the state would announce an all fraud.
And there you go, Mr. Jackson. State dismiss the charges against you. Best, it's a good day for you.
Yes, sir. Thank you.
Best of luck to you. You take care.
Yes, sir.
Demetrius Jones.
Mr. Jones has been arrested in Bay County and is held there.
Okay. Let's come back on July 8th at 1:30.
Okay.
See where he is, if he's been released or what's going on.
Right, and I think we might end up being able to work out some global resolution with whatever's going on there.
That'd be good.
All right, thank you, Ron.
Yes, thank you. Josette Jones. Ms. Jones, good afternoon.
Right, and Ms. Jones? In Ms. Jones' case, I did just make an appointment with her to meet with me on August 5th by Zoom. So if we could pass her to that pretrial date, we had negotiated with the state, but they had declined, I think, what she was going to do. So
Any issue with speedy trial if we move this to August?
at this point, we would waive the speedy trial. to
Our speedy
be able
trial
to
is
meet with her.
waived. Ms. Jones, and we'll see you August 12th at 1:30 now.
Thank you. Before Ms. Jones leaves, on June the 16th, the court signed an order revoking Ms. Jones's bond and ordering her held without bond. I could not find in the system where the clerk's office issued a capias to that effect, but I would ask that she be taken into custody on the court's order.
Well, let me
I
see.
have my daughters and everything and medical I need to take care of and bills right now, if that would be fine.
One moment,
And I
ma'am.
can put myself in.
One moment. Let me review the motion and the order, and then I'll hear from you, okay? All right, Miss, and what's going on? You say your daughter's here with us?
I have my daughters and everything, and everything, pets and animals that I need to get taken care of and to another house. If I could have at least 2-3 days to turn myself in.
How old are your children?
They're 16. I don't have animals at home that are actually in my house.
Where are your children gonna go? Basically, you're gonna go
They'll
into,
go to their dads.
you're gonna go into jail,
Okay.
until you
That's
resolve
why
this
I was
case.
asking, can I turn myself in either tomorrow or the next day of the month to get my kids stuff packed to go to their dad?
Miss Judy, will I be in Gulf County tomorrow, Bay?
Judge, you will be in Bay County tomorrow. You'll be back here on Thursday.
Mr. Patterson? I would otherwise take her into custody, but I don't want to have to, if she has children at home, I don't want to have to get DCF involved in,
That would be fine.
what I'll do. You turn yourself in tomorrow morning, ma'am, by 9 a.m., okay? I'm gonna make a note.
Thank you, Your Honor. I don't.
Yeah, I have an order granting the state's motion to revoke bond. Basically, she was out on bond, and while she was out on bond, she picked up a new charge of possession of methamphetamine, possession of paraphernalia, and no valid driver's license. Looks like I entered that on June 16th.
And I see that when I'm looking in CCIS, I see the new, I guess, but I'm not even seeing how to pull up her old under her name, so.
Ms. Jones, go home, take care of your children and your pets. Turn yourself into the Gulf County Jail tomorrow by 9 a.m. I'm making a note right now. I'm gonna call the captain out there at the jail about 10 o'clock Eastern and see if you turned yourself in. If not, the sheriff's department will pick you up and we'll go from there, okay?
Thank you.
Hi, Ms. Jones. That's fine. She's gonna turn herself in tomorrow morning. Ms. Jones? We got the time correct? What time is that? Eastern time? Gulf County Jail, Eastern. Jonathan Jones?
Judge, we have a plea agreement worked out with Mr. Jonathan Jones. I learned yesterday that he was on a DOC transport from Bay County. The agreement we've got worked out is a concurrent plea with the sentence that he got out of Bay County a few weeks ago. Like I said, they sent him to DOC before we could get our hands on him. So I'm going to coordinate with the reception center and hopefully by the 8th, we can do a Zoom plea and get that taken care of while he's still up there.
That sounds good. We'll bring Mr. Jones back July 8th at 1:30. Timothy Jones?
Judge, Mr. Jones has a couple of cases, actually 4 cases on the docket. There's one matter in particular that we need to get taken care of before we can come to a resolution. That's something that is scheduled to take place tomorrow afternoon after our county court docket. So I would ask that we just bring Mr. Jones back Thursday and we'll take care of this case or these cases on Thursday afternoon or Thursday morning. I'm sorry.
Mr. Jones, I'll see you Thursday. That's June 26th at 9:30.
Yes, sir.
Andrew Cooner?
Good afternoon, Your Honor.
Hey, good afternoon, sir.
Judge, in Mr. Cooner's case 2554 CF, at this time, Mr. Cooner is going to change his not guilty plea to a plea of no contest to count 2, possession of drug paraphernalia, a misdemeanor. Count 3, reckless driving, also a misdemeanor. Count 1 is being consolidated for the purposes of the plea. As to the sentence, he'll be adjudicated guilty of both count 2 and 3, 6 months of probation to be supervised by the county probation department. Court costs, fees, and fines are going to be ordered at $473. We'll waive any additional fees that need to be read. Cost of supervision is $50 per month. Do a substance abuse evaluation and follow any recommendations. Must enroll within 30 days of today and complete any recommended treatment on the first attempt. Submit to random urinalysis. The first one within 30 days is going to serve as a baseline. And as to the reckless driving charge, the Department of Highway Safety Motor Vehicles may apply additional sanctions to his license. We will stipulate there's a factual basis for the plea. And again, the case is being transferred to county court for supervision.
Also, my insurance, that's what I'm taking for my insurance, and they've already have revoked my license.
Okay.
And then I just recently pulled out the records to my thing, and it said that they added, I think, 3 points to my license for open container.
Okay, that's a civil infraction. We don't deal with civil infractions in criminal court.
I was gonna ask you on how could I possibly get that off or not?
Well, that's going to be a question between you and DMV, and I don't know what happened with the civil infraction tickets you got for the open container, if it was contested or any of that nature, but that's going to be between you and DMV and the traffic court judge.
Because I figured.
We don't deal with civil
the
infractions.
DUI, I got my DUI job.
There's no DUI, it's reckless driving and possession of
That's what
paraphernalia.
I figured, because we targeted for open container, but I'll talk to DMV about that.
Yep, it's not right there. Yeah, but but all the, like I said, those civil infractions, they're dealt with civilly outside of the criminal court.
Okay, yes.
We've all signed it. We just
Mr.
ask
Cook.
that you impose sentence and take this as an
Yes, sir.
county
Yes, Your
judge.
Honor.
That's how you want to resolve your case?
Yes, sir.
All right, you'll be sentenced as announced by Mr. Hill. The matter will be transferred to county court and count one will be consolidated. Best of luck to you, sir.
Yes, sir. Thank you.
All right, you need,
Brian Leffen?
when you leave here, you need to go back here to the county jail, to the front door and check in with county probation officer.
Okay.
It's gonna be Officer
Can I
Knott.
write this on a note card just so I don't forget? If you don't mind, I'll write it on this.
You can take that right now. Just right up there, Officer Knox. KNOX, yes. You walk out of this building, go to the building directly behind us and check in right now.
Yes, sir. And
Step to the side, Mr. Cooney.
Yes,
You can
sir.
talk to him over there. Mr. Patterson, everything okay?
Yes, sir. What was
Okay.
that thing that you told me to do, the evaluation course?
Mr. Knox will go over all that with you.
Okay, yes, sir.
All
Thank
right,
you,
Take that with you.
Yes, sir. Thank you, Your Honor. Have a
Yes.
good day.
Mr. Leffen?
Judge,
Yes, ma'am.
Judge, on Mr. Levin's case, it's my understanding that he is still undergoing competency restoration treatment. Don't have an updated report on this case. I think it'd be appropriate to bring him back August 12th, and we'll let you know where we stand at that point.
All right, Mr. Leffen, continue to meet with the counselors and we'll see you August 12th at 1:30, okay?
All right,
Sign that notice. You're free to go, okay?
okay.
Yes, sir? What time does daycare close? Okay, it's not 2:00 yet. Curtis Lewis? We all have someplace we have to be, sir. Georgia? You're from Georgia?
He is, Judge.
Oh, come on up.
Yes, sir.
What's your last name, sir? Rutledge?
Judge, Mr. Rutledge Johnson's here, 2559 CF. At this time, he's going to withdraw his not guilty plea, change that plea to no contest to count one, fraudulent use of a credit card more than 2 times within 6 months. That's a 3rd-degree felony. Count 3, grand theft over $750, also a 3rd-degree felony. Count 4, grand theft over $750, also a 3rd-degree felony. As to count 2, that will be consolidated into count 1 pursuant to the holding in Neal versus State, 109 Southern's 3rd, or 1245. The sentence is going to be an adjudication of guilt, 60 months of probation. Court cost and fines are assessed at $1,005. Cost of supervision is $20 per month. Restitution is ordered in the amount of $3,678.77 to Port Wine and Spirits and $2,457.84 to the Haughty Heron. DHSMV may apply penalties to his license. We stipulate there's factual basis for the plea, submit to a DNA sample, and will waive individual reading of the court costs and fines and fees. Stated Mr. Rutledge is a Georgia resident. He's on supervision in Georgia, and this will run concurrently with that supervision up there. Sign right there.
Thank you, Your Honor. Yes, sir. All right, Mr. Rutledge, you'll raise your right hand for me.
Yes.
Is this how you want to resolve your case, Mr. Rutledge?
Yes.
How old are you?
28,
You can put your hand down. What's your highest level of education, sir?
high school.
Are you under the influence of any alcohol, drugs, and medication? Anyone promise you anything other than what Mr. Hill just told us?
No.
Anyone threaten or coerce you in any way to get you to enter this plea?
No.
You're waiving your right to a trial by jury?
Yeah.
And you're waiving your right to appeal anything other than an illegal sentence?
Yeah.
I have to advise you, if you're not a U.S. citizen, by entering this plea, it could subject you to deportation. You understand that?
Yeah.
You satisfied with Mr. Hill's services?
Yeah.
Counsel, either of you aware of any exculpatory DNA?
No, sir, Judge.
All right, Mr. Rutledge Johnson, in case number 25 CF 59, you will be adjudicated guilty of counts 1, 3, and 4. Count 2 will be consolidated into count 1. You have court costs and fines in the amount of $1,005. Mr. Hill, you waive my reading of the discretionary costs and fines.
Yes, sir, Judge.
You'll be placed on 60 months of probation. Your cost of supervision is $20 per month. The restitution is $3,678.77 to Port Wine and Spirits and $2,457.84 to the Haughty Heron. Are you employed?
Not current.
Yeah, I need to make a correction to that plea form.
Okay,
That amount to the Port Wine and Spirits, that business is actually sold, so that actually should be paid directly to Boyd Pickett.
you say that name again?
Boyd, B-O-Y-D, Pickett, P-I-C-K-E-T-T.
How are you gonna pay this restitution, Mr. Rutledge?
I mean, I get a job, cash.
You searching for a job?
Yeah.
All right, the Department of Highway Safety and Motor Vehicles may apply additional penalties. You must provide a DNA sample. You stipulate there as a factual basis. You have any questions for me? You got 30 days from today to appeal the judgment and sentence of the court. You cannot afford an attorney, won't be provided for you. I believe you can transfer your probation to Georgia. There's a fee that applies.
Interstate compact fee, and these folks explain all that to you.
All right, Mr. Rutledge Johnson, best of luck to you and safe travels.
Thank you.
Curtis Lewis.
I spoke with Mr. Middleton about Mr. Lewis. If we could pass him to 812, we'll either have him resolved or back on a PTI.
Okay. James Lewis. Stephen McDaniel.
And Mr. McDaniel, we remailed his discovery to him back in 4/3, and with the offer, we hadn't heard from you recently, but he did bring me something on. It's like the drives that go in the camera, that kind of drive. I don't know what
Okay.
it's called. And so I just don't have a way to open it here, but he's gonna try and email me it
I
as
already
well.
did.
I don't know that I got it, but we'll look.
All right, when do we need to return on his case?
So if we could pass him to a trial management, maybe in August or September, either way, whatever we have in that time range in the fall, I guess, beginning fall. We did file a notice of alibi a while back. I think he's moving toward a trial because of just where we are.
Okay. Mr. McDaniel, will see you for trial management on September 11th and jury selection September 29th.
Yes, sir.
All right, thank you. September,
29th, September, I say 11th or is it the 9th? Yeah, 11th
Okay,
for trial
11th.
management and 29th for jury selection.
okay, thank you, Your Honor.
Ms. McFarlane? Ms. Judy, you'll let the lawyers know who are present for the 3 PM. I'll be right with them as soon as we finish the criminal docket.
Yes, sir.
Ms. McFarlane?
Judge, on Ms. McFarlane's case, I've met with her a couple of times and she's in the process of gathering some potential mitigating evidence for me to present. If we could set this for the 7-8 docket pretrial, give her a little bit more time to get that information to me so that I can present it to the state court.
Ms. McFarlane, we'll see you July 8th at 1:30, ma'am. You been doing all right?
Yes, thank you.
Paul McKenzie?
Judge, on Mr. McKenzie's case, I'd also ask that his pretrial be rescheduled for 7-8. I need to get up with Mr. McKenzie and see how we might be able to get this case resolved. I think we can get it resolved. I just need a meeting with Mr. McKenzie.
All right, Mr. McKenzie, we'll see you July 8th at 1:30. What's your name, ma'am?
Thank you, Your Honor.
All right, come on down, Ms. Ross.
Schedule a time with.
Oh, I'll call you, okay?
All right.
Is your phone number still the same?
Yeah.
Okay, I'll call you. Judge, on Ms. Ross's case, we scheduled depositions yesterday for, I believe, August the 7th was the date we were able to nail down. So I would ask for the August 12th pretrial date. And like I said, we can update the court on where we stand after those depositions are completed.
Ms. Ross, we will see you on August 12th
Okay,
at
thank you.
1:30. Sir, front row, what's your name in custody?
Mr. Wagner.
Come on down, Mr. Wagner. I'm gonna try to get those in custody out of here.
Judge, I was going to bring Mr. Wagner back on Thursday of this week. We've got a plea offer for 180 days. And I believe that's going to be the final offer, but Mr. Wagner wanted me to run a few things by Mr. Patterson. I just need a little bit more time, but
All right, we'll see you on the 26th. That's this upcoming Thursday at 9:30, Mr. Wagner. Sir, what's your name? All right, come on down, Mr. Strickland. Yes.
And I did meet with Mr. Stripling on 5/29. I did need to file a discovery exhibit with some new witnesses that he had listed there and in some correspondence to me. I just had not had a chance to do that yet.
I'll take probation, house arrest, whatever. I mean, I got a job out there. I'm trying to save my house. I mean, I'll take whatever.
Don't say whatever, Mr. Strickland.
I mean, I
You're
got
facing
a job out there. I'm trying to save my house. I
So
mean,
you're facing a first-degree felony. Well, actually, it's aggravated battery, a second-degree felony. Don't say you'll take whatever. That's up to 15 years.
It's up to 15 years in prison is the max on that. So don't say whatever.
And I don't know your criminal history. I don't know your background.
I mean,
Don't say that. Just work with your attorney. I don't know your score sheet. I don't know your background. You say you'll take whatever and I sentence you to prison for 15 years. It'd be a problem. So just work with Ms. Miller. See if we can get down to what's going on
I just need
and
somebody to communicate with me. I mean,
she'll be out to communicate with you. Let's come back on 7/8 at 1:30.
All right,
Ms.
and I-
Miller, if you'll meet with Mr.
Correct,
Strickland
yeah,
before
I-
then.
I think I've already asked Cindy to set up another meeting with him. And then also, I know that he has court tomorrow, but I'm scheduled to be in trial. No, this isn't before the court, but since
Okay.
he's here, I just wanted to alert him. I am filing a motion to continue tomorrow's court date because I'm supposed to be in a jury trial tomorrow morning.
We'll bring you back on 7/8 and Ms.
All
Miller
right.
come out to see you before then, all right?
Thank you.
Mr. Messer, you're with us?
Judge, on Mr. Messer's, this is case number 25-3. He has this case, plus he has one more that's scheduled for your arraignment docket next month.
Okay.
In this case, I filed a motion to suppress based on a illegal traffic stop. I believe Mr. Patterson had an announcement.
Yes, Your Honor, the state would announce the no process based on a well-founded motion.
Oh, there you go, Mr. Messer. Your charge is dismissed. If you don't have any other hold, you'll be released from the jail.
Yeah, your bond was revoked in this case. You've got a bond in the other case. You'd already posted. So the bond in this case was revoked, but this case has been dismissed.
So I can get released today?
If you posted bond on that other
Yes, I
case.
already posted. Yes, sir.
All right, take care.
Thank you.
Ms. Peters, I see you looking at me. Ms. Lauren Peters, come on up.
Go see the officer.
How are you doing, ma'am? I'm doing well. We're here for your, looks like a VOP pretrial. We have an agreement.
You told me that if I brought back some hours that you would work with me. So I went and I got hours. I have to make my payment, but I didn't know what you were gonna do today, so I can pay it all. But I didn't know what you were gonna add to it. I just wanna be finished.
Was that just community service work and money?
That was my understanding, Judge. That was hours that she had not yet completed and financial obligations.
And I didn't get 100, but I got 60 of them.
Okay. When is your probation scheduled to terminate
I was supposed to be terminated on the 13th.
of this month? Have you paid any money toward your court costs and fines?
I have the $300 left and whatever you give me today.
Actually, it looks like it was, you paid that off. It looks like, does she owe $3, Madam Clerk?
Anything, I have a zero balance.
You have a zero balance, Madam Probation Officer, any balance?
Should be 321.82. That's what I owe. And whatever you give me.
All right, 321.82. And you got how many hours?
60.
60 hours done. And that was the only basis of the violation? You done everything else?
Yes.
All right, the 321.82 will be a civil judgment. I'll waive the additional 40 hours. I'll unsuccessfully terminate your probation. Best of luck to you, ma'am.
Does this need to go into court file, Judge?
And you go in the court file, show that you completed it.
Do I need to do anything?
You're off probation and you need to set up a, Ms. Peters, that $321.82, you need to set up a payment plan with the clerk's office. Well, you probably want to go, go to probation. Okay. Well, if you have the money, go and pay probation.
I called her and she said, just wait. She told me to tell you that it's down.
Yeah, just go ahead and pay it. Congratulations to you. Why wouldn't I listen to that? If it's down, it's down. Yes, and I'll waive the additional 40 hours. Adria Moina. Good afternoon, ma'am. How are you doing?
Good. I'm good.
Judge, after consulting with Mr. Patterson, I've asked that we bring Ms. Mawina back on 7/8, please, for a pretrial.
All right, ma'am. We'll see you July 8th at 1:30. Did we already handle Mr. Nicer's case?
This morning, Judge.
Okay.
Please, we're up to Mr. Peterson now.
All right, Charles Peterson.
Okay.
Mr. Peterson, how you doing?
So good.
I was gonna say, you can sit down, have a seat out there, Mr. Peterson. You're fine. If you can't make it up here, just have a seat.
My hip, I got a hip.
No, just have a seat, Mr. Peterson. You don't have to walk up. We know you're here. If you're in pain, no need to come on up. Does he have a plea?
He does.
Has he signed the plea form?
He has not, so I can.
Well, he can hear me. I can hear him. We can do what we need to from there. You don't have a walker or?
No, I don't have.
You don't have any crutches? When did this happen, Mr. Peterson? You haven't been to the doctor?
Yes, I've been to the doctor.
And they didn't give you anything to walk with?
They gave me some painkillers.
Well, you're gonna have to come forward because you're gonna be fingerprinted. So take your time.
I will walk, it just gets stiff when I
And
get out a little bit.
I would say I didn't give him the form to read over because this is my client that has some
understand.
difficulties. So if you
I'll
could
talk to him.
announce it and just go over that with him, that would be great. But the offer, I think the offer was that he would be entering a plea to misdemeanor battery. And that charge obviously is amended and that he would serve 30 days in the county jail. He has credit for 2. I think Mr. Peterson had a request, but I don't,
Yes,
you were, but I,
See, I had asked her, when she had to stay, give me 30 days with my jail credit time. Yeah,
And you did. That's what they gave you, 30 with 2. So you'd be going in right now.
yes,
Okay, you ready for that?
yes, I'm ready, but I need to go back to the house. I got 2 dogs and 4 cats.
Okay, they'll be all right.
Yeah,
You can contact the family member. You know you're going into custody today. Contact the family member to take care of them.
I accept that.
All right?
I accept that.
Okay, all
I
right.
got I got a basket out front though, I need, for them to put it back there.
Okay. Not sure to do with his bicycle, but he has a bicycle out front that,
It's blue with big tires on it.
yeah. We'll make sure your bicycle's taken care of, Mr. Peterson. Yes, sir. Mr. Peterson?
It's all right with you, Gary? Huh?
It's all right with you if I get it.
Oh, no. I know, no, I'm not the
He
right.
said it's a mongoose.
He wants to write it back when he gets out. It's okay.
All right, Mr. Peterson, you raise your right hand for me.
Yes.
Mr. Peterson, it looks like you agreed that the state will reduce the charge from felony battery to misdemeanor battery. You asked for 30 days in the county jail with credit for 2 and the state obliged. Is that your understanding? How are you going to resolve your case? You can put your hand down. Anyone promise, threaten you in any way to get you to withdraw your plea, enter no contest plea?
No.
This is how you want to resolve your case?
Yeah.
Are you under the influence of any alcohol, drugs, and medication other than the pain pills that you were given?
No. Yes, right.
Do you understand what you're doing?
Yeah.
You're 67 years old?
Yes.
You're clear-minded?
Yes, sir.
I understand you're waiving your right to a trial by jury? And what's the court costs and fines?
They would be reduced to civil judgment, but I would assume they'd be that. It would be $722 that's reduced to a civil judgment.
Well, I have to pay that.
You'll have to pay it if you want to get your license, but you can set up a payment plan over time, long periods of time with the clerk once you get out. But it's a civil judgment like a debt. Okay.
All right, Mr. Peterson, I'm going to accept your plea, sir, in 24 CF 208. You'll be adjudicated guilty of misdemeanor battery, sentenced to 30 days in the Gulf County Jail, given credit for 2. You have court costs and fines in the amount of $722 that will be reduced to a civil judgment. You got 30 days from today to appeal the judgment and sentence. If you can't afford an attorney, one will be provided. Best of luck to you, sir. Yes, sir.
Yeah, I get the jail credit time off of that 30 days that I get.
Yeah, you got 2 days jail credit.
Jail credit that you were in for. You were only in for 2 days.
No, if I stay jail, I stay jail for 23 days. then.
I'll look at it right now, Mr. Peterson.
Yeah,
Well, but
I'm born, I paid 23.
it did start, I think, as a misdemeanor, so that might be an issue. I mean, he might be right.
I'll see. Give me one moment.
Yeah.
Did y'all agree to his credit or did you all agree to 2 days?
I'll agree to what the jail says his credit is.
Okay. Looks like he was arrested on 11/18 of 2024, 17, and he bonded out on, is it 12/18? I have a bond filed 12/18. Cause that booked in 11/17, bonded out on 12/17. You got 30 days jail credit, so you're not going to jail today. You got 30 days in the Gulf County Jail with 30 days credit. We need to, so you can take care of your mongoose. You're not going to jail. Just whoa, you moving fast now.
I have to move like that to get my leg. I'm telling you the truth.
You got me, Mr. Peterson.
When I sit out, but when I stand up, I got to.
It's fine, Mr. Peterson. Go, Mr. Peterson. Just.
No.
That's it.
When I sit out, it gets good. When I stand up, I have to move.
You got me on that one, Mr. Peterson. Hunter Rollins.
After we take care of Mr. Rollins, I need to recall Mr. Rutledge Johnson
Okay.
up real quick. Judge, on Mr. Rollins' case, all the discovery's been completed, and we need to go ahead and set this case on the September trial management, September jury trial date in the event we're not able to get it worked out.
All right, we'll see September 11th for trial management and September 29th for jury selection.
Yes, sir.
And before we call the gentleman back, did we already handle Mr. Presnell?
We didn't, Judge. Mr. Presnell is in a residential treatment program. I spoke to him last week and told him that I would stand in for him today, Judge, and asked that his case be scheduled for 8/12.
All right, we'll bring
He's
Mr.
gonna meet with me after he gets out of the program.
We'll bring Mr. Presnell back on August 12th at 1:30. Yes, sir. Come on up.
Judge, on Mr. Rutledge Johnson, as I stated earlier, he's currently being supervised on probation in Georgia. When he checked in, Florida told him he couldn't leave the state of Florida until he pays the $100 compact fee.
That's true.
And we were out, I was gonna told him I'd ask permission for him to go to Georgia. He doesn't have the $100 with him right now to get that, I mean, he's being supervised in Georgia. So he's not going anywhere other than go back to Georgia and be supervised. And the intent was for this probation to be served concurrently with the supervision he's on in Georgia. He's kind
Well,
of
the-
down here,
yeah,
he's in a bind right now.
Well, the statute, and I don't have it in front of me, I believe it reads before you can transfer your probation, you have to pay the transfer fee, but it doesn't say you can't travel. I don't have it, you have that statute in front of you? But I believe the language is before you can transfer your probation out of state, you need to pay that fee.
Yeah, no, I'm gonna pay the fee. I just didn't know. I don't have it on me now. So when I called him and was talking to him, he was like, "Well, you can't leave the state of Florida. You have to come and and I'm like, it's like I don't have the $100. So he was like, go in there and see if they could take back your plea and just once I get the money, redo it. I'm like, I could go and ask, but I don't really know. So.
Is it a standard condition of probation? They can't travel outside of the state? Madam Probation Officer?
If he goes and he checks in with us today, his officer can potentially allow him to go back to Georgia, but he's technically still gonna be supervised in Florida.
Yes.
However, after 7 days of him taking the plea, if he doesn't transfer, he'll no longer be considered an immediate transfer. I don't know if it would affect it differently if he's already supervised in Georgia, like on probation there. Because usually if they don't transfer out the same day and you give more trouble, that you go home and get the money and come back, then they have to remain in Florida for the 45 to 60 day transfer process. So that potentially might come into play if he doesn't come back within 7 days from today, to immediately go to Georgia.
Would he have to check in with probation in any event, once he enters the plea? In order to transfer his probation to Georgia, would he have to check in person?
Like with us?
Yes.
Yeah, he would still come and see us today. Whatever officer he gets assigned to, then they would be able to issue him a travel permit to go back to Georgia and hopefully come back with the money order within the next week, so that way they can then initiate the transfer.
When can you get the $100?
Probably in like a week or two. I gotta get a job.
So also after next Tuesday, the fee is gonna be $125 as of July 1st, so it'll be $125. So then he also.
I'll still be able to pay it in like a week or two.
What do y'all want to do? I can hold off on the imposition of sentencing and bring it back on 7/8.
Or
y'all have another plan?
that was what we were just talking about, judges. I mean, he's already entered the plea and we not hold off sentencing until he can come back either 7/8 or 8/12. I don't.
I mean,
But like I said,
oh, sorry to cut you off.
I'm just saying, because when we, whatever sentencing date we give you, I mean, you're gonna have that fee money in place to.
8/12 would be like a perfect. If I could do that. I'll come back. I hate that I even have to come back, but I mean, I didn't know. If I would have known I would have had to pay $100, I would have made sure I would have got the $100 to pay it, but I didn't know that though. I'm thinking I'm gonna just be able to just switch it.
What's your last name?
Rutledge Johnson. I'm so sorry for the
No,
inconvenience.
no need. You're not inconveniencing me. What we'll need to do, are you moving to withdraw the plea? Because if he's already entered the plea and sent it to me, everything, all the time for everything is gonna start running today. So if you move to withdraw the plea, I'll grant the motion to withdraw the plea and we'll bring him back 8/12 and we can redo it, start anew.
Are you okay to do that?
Yeah, withdrawing the plea not gonna like do nothing to me,
No.
right?
No, we're just gonna come back on what you're gonna do. You're gonna go back to the point you were when you come in the courtroom today. We're gonna set everything out to 8/12. When you come back 8/12, you need to bring that $125 with you. We're gonna redo everything, reimpose the same sentence that you just got, and it'll be effective that day moving forward.
Okay.
And like I said, you bring the $125, so when you check in with probation locally, they can go ahead and do your transfer and send you back to Georgia.
Okay, all right.
All right, so I'll grant your motion to withdraw your plea. We'll bring you back on August 12th at 1:30.
All right,
And we'll
thank
see
you
where we
so
are now.
much.
Absolutely.
God
Robert
bless.
Rosenwald?
Just make sure you have that 125 when you
Oh,
come
yeah,
back
yeah,
next
yeah,
time.
I know now. Thank you. You have a good, wonderful day.
Yes, sir. Safe travels.
Can you take this? And just throw it away?
Excuse me. Judge, on Mr. Rosenwald's case, I would ask that his case be reset for 7/8. He wants me to continue negotiating with Mr. Patterson on his case.
All right, we'll see you July 8th at 1:30.
You got to sign that, Mr. Rowan. You got to sign that notice, sir.
Catherine Salter, excuse me, Vanessa Ryan.
Ms. Peskin.
Past her to September 9th.
Okay, Catherine Salter.
And Ms. Salter, I told her that I would sign for her. I think she's got a waiver. We were trying to get that paperwork to her to sign, but
Okay,
she's been declared incompetent by Dr. DeRico. I did submit the order today.
okay. Mr. Patterson?
Just got on my back burner.
Yes, Your Honor, that order was based on intellectual disability. I don't think if I have another evaluation done, that's going to very much, so I would agree with you.
Okay,
And
all right, I have the order here. I'll sign the order.
you might want to check it. There was one thing about, I copied it from someone else. I think I asked her to check the contacts. I think the order that I had that was a sample said peaceful contact, but I didn't know if there was a no contact.
You know about that.
Yeah, so you might want to change that. That was just the only thing I didn't know. And it may not be checked. I told her to leave it so it could be checked, but I didn't think. Although I think the facility itself is closed and the people that were involved.
All right, so I'll enter the order. I'll change peaceful to no contact.
Yeah, that's fine.
Actually, you said incompetent?
Yeah, she's incompetent.
Yeah, I don't have a report. I'm gonna have to make independent findings.
We did submit the report, I thought.
Submitting a report doesn't mean I receive it.
Okay, sorry,
Did
I
you-
will tell her. Sorry.
Did you send it to Miss Judy?
I will tell. I can email it directly, or we should probably file it. Then I thought he filed it.
Yeah, I don't receive notice when something's filed. Okay.
Sorry, I thought that maybe that's probably why we didn't send the order or send a. Let's see. Motion. There it is.
And where is this order? Where's she going?
Where it says peaceful.
Oh, no. Where are we sending her to?
I think it's being referred to life management. That's where I was unsure because I have never had someone ordered incompetent in this way here. So I just didn't know. I assumed it's the same facility, but that's what took a minute. Everybody said yes. It's just refer them to life management and APD services at the bottom, I think.
Okay, perfect. That was the recommendation. I reviewed Dr. DeRico's report. I'm going to find independently that Ms. Salter is incompetent to proceed, and she'll be referred for
So
outpatient.
Is it through life
Restoration,
management?
yes.
Okay, that's where I was getting confused. I didn't realize that that was who operated it, I guess. Okay,
All right, Sharon Scott.
thank you.
Judge, on Ms. Scott's case, she advised me of some very important information I need to follow up on before we started court today. So I would ask that we bring her back on 8/12. Give me a chance to get this information from a separate hearing that I think is very important for myself and Mr. Patterson.
All right, Ms. Scott, we'll see you August 12th at 1:30, ma'am.
Yes, sir. Thank you.
Larry Shepherd.
I thought Mr. Shepherd was going to be with us via Zoom. He lives in Miami.
I saw the name Larry Shepherd on Zoom.
Thank you, sweetheart.
Mr.
Appreciate it.
Shepherd, are
Have a
you
good
with
day,
us, sir?
okay?
Excuse me, Judge, he is on Zoom.
Yeah.
Okay.
Judge, in this case, this is one that I have been talking to Mr. Patterson about a motion to suppress. He was going to talk to the officer that made the traffic stop and see if we could come to some agreement. I don't know if were you able to get that done? All right. Let's set this out 8/12, Judge, and we'll continue to pursue that.
Okay, we'll see Mr. Shepherd on August 12th at 1:30.
We trying to press and get those out.
You're free to discharge, Mr. Shepherd.
You lawyer, Mr. Hill.
All right, thank you, sir. I'll be in touch with you.
All right, thank you. Have a blessed day.
Yes, sir.
Yes, sir. Take care. Mr. Thomas, come on up.
Thank you. Right. Mr. Thomas's case, he did come and meet with me. We did discuss the issue of doing the motion to compel the CI information, and he asked me to file that. I did file that this morning. And then, so it's been filed. We probably, if we could set this for either the next pretrial or a motion hearing, if that's possible.
All right, we can set it for Thursday, or we can set it for next month.
It's for 17.
Okay, we'll bring you back, Mr. Thomas, on July 10th for that motion hearing, sir. We'll see you then.
All right, thank you, Your Honor.
That's at 9:30.
All right, thank you.
Henry Van.
So he'll sign for the 710.
Judge, I think we're pretty close to having Mr. Van's cases resolved. I just need one more meeting with him. So if I could put him on the 7/8 docket, I'll get him in on the July 1st for appointment.
All right, Mr. Van, we'll bring you back on July 8th at 1:30, all right?
Thank you. You got to sign.
Ma'am, what's your name? Are you here with Mr. Van? Sir, front row, what's your name?
Strickland.
Oh, Mr. Strickland? Come on up.
Judge, I'm gonna ask to bring Mr. Strickland back on 7/8 as well, see if we can get this case resolved.
All right, Mr. Strickland, we'll bring you back for a pretrial conference on July 8th at 1:30.
Yes, sir.
Is that everyone for the afternoon docket?
It is, Judge.
All righty, thank you. I will see you all Thursday morning.
Thank you, Judge.
We'll conclude. That concludes our criminal docket. We'll go ahead and turn off the blue man. Disconnect. Thank you.
Hello. Oh, so here's the thing. When someone says hello, there's usually a response back. So let me just tell you what's going on. You're being rude and disrespectful to your probation officer. You act like you're not on probation. When I say there's to be no contact, there's to be no contact. And now you're using profanity towards probation officer like you're not on probation and that this is somehow his fault. It is not. It's all your fault. You're here because you're on deferred adjudication for injuring someone who's an elderly person. That's why you're here. You're not on probation because he placed you on probation. You're not on probation because he committed a crime and you're taking the time for him. You're here because of your actions and you're acting as though none of this is your fault. This is all your fault, 100%.
I'm not acting like none of it's my fault, and I take accountability for what I've done.
No, you have not taken accountability. Did you take accountability for using profanity towards him? No.
No, I didn't.
And I don't know why people think that when you're in a situation where you should be using logic to find what are using your cognitive skills to decide how I'm going to proceed with this, instead, you go after your probation officer. And the probation officer, let's be honest, every defense attorney will tell you a probation officer holds your life in their hands. Because you know what? Let's say you're supposed to report to probation at 9 a.m. and you end up reporting at 9:05. Guess what? You have not reported at 9 a.m. A probation officer can say, hey, that's a no report. But sometimes they may take sympathy on you and say, I realize what's going on. They're here, but they don't have to do that.
Yes.
And you using profanity towards a probation officer is not helping your case at all.
And I understand that. Then the reason why I did, and I didn't, I just said the F word because he called me a liar. And when I didn't lie to him about any situation that was going on, I sent them all the information from my legal aid lawyer. I sent them everything. He even gave me his personal number for me to contact him. When I had to go to the emergency room and had to get a blood transfusion, he even offered to take me there. He called.
This is not your blood. This is not about your blood.
I know it's not about my blood, but it's he basically, when I went to go see him, he was telling me that I lied to him, which I never lied to him about anything.
No. This starts with you wanting to go to a location where I said you are not allowed to have contact. That's where all of this came up. Then everything snowballs into something else.
Yes, ma'am. And I did exactly what you told me to. I didn't go to that location. I filed my police reports. I did everything that I could do without going to that location.
All right, so then that was it. I don't know. What do you expect him to do? Like, I like for people to just put their cards on their table. Sometimes people are like, judge, but I like everybody to have an understanding. So you go to him because you want to go to a location and retrieve items when I told you you couldn't go to that location. So we're back to the point. What did you want him to do?
I asked him, was there any assistance or any way that I could? He told me, I don't know. He told me he didn't know, he couldn't help me. So I didn't have no other choice but to call the police, make a police report. I had my daughter, she's 16 years old, to go there. When she went there, she took pictures of everything that was outside.
All right, so again, what did you want him to do? He said, hey, I don't know, there's nothing I can do for you.
When I contacted Ms. Adams, she told me to ask my probationer if there's any assistance that he can help me or provide without going to that location.
And he's saying no.
And he said no. And I told him I don't have no other choice. My children is 16 and 18. They didn't have the money. They don't have money for you all. My daughter just quit her job because no one was able to take her to work. So I didn't have nobody else to help me get
So
anything.
again, I don't know how this translates into you using profanity against him. He's like, I can't help you. And honestly, it's not his job to help you get your things. Really, you know what a probation officer's job really is? And they'll correct me if I'm wrong, but their job is to make sure that you abide by your conditions. Everything else that they're doing is just extra, but that's not their job. It's not, for example, if you can't pay your utilities, it's not their job to find places for you to pay utilities. They'll do it. They'll say, here's some places that you can call. But that's not his job. And if he tells you, I can't help you with getting your things, again, we're back to the point. He says, I can't help you. So what do you want him to do? He's like, I can't help you.
And
how does that translate into using profanity against him? And then telling him, sending him an email, telling him all this is his fault and it's on his shoulders. It's not. All of this happened because of you. Guess what? You can't go to that location because you injured an elderly person. That's why it's all your fault. And there are consequences for all our actions.
It is, and I communicated with him. I told him everything. I sent every case number. I even sent him my legal aid information. I sent everything. I tried to do everything the right way before it even went out of hand.
But see, here's what you don't understand, and you're not internalizing what I'm saying. He is telling you, I can't help you with that. And you still keep going back to him. He's already told you, I can't help you with that. Giving him numbers to your legal aid, giving him numbers to this person saying, we're trying to help her get her things. He can't help you with that. His whole role is to supervise you on probation. That's it. He can't say, you know what I'm going to do? I tell you what, let me go over there and get your things for you. He can't do that. That's not his job. Now, if he offers to do that, great, but he doesn't have to. He has told you more than once, I cannot help you with that. I still don't understand how that goes and translates into you using profanity against him. His job is hard as it is. And then to have somebody come in and use profanity against them, that's an issue. And then to have you go into that location when you know you're not supposed to, that's an
I
issue.
never did go to the location. I didn't. I had to call the police from a different location. To make
All right, so you called the police and then what happened?
I made the police report. I went down to the property. I also went down to 315, the headquarters, to fill out all the information because the day I was arrested, everything was stolen. My car, my credit cards, everything. So I'm trying to do everything that I have to do the best way that I can, the right way.
All right, the right way is not using profanity against your probation officer. That's not the right way. The right way is not being disrespectful. And you know what? This whole thing with the injury to the elderly, where I ordered anger management, you do have an anger problem. Because when people tell you no, you can't accept that, you take it to 100. He said, I can't help you with that. And then you use profanity against him. You're calling him all sorts of names. Nobody likes to be called out there, give a name.
I didn't call him out his name. I just said it was fine. I didn't have no other choice. So I would have to figure it out.
No, we're not here because you said it was just fine. Where is the officer? If you can come forward, please. All right, so you're Officer Wolf?
Yes, ma'am.
All right, so let me ask you a question. Are you able to go to her former location and get her items for her? No?
No, ma'am.
That's your answer, no. Are you able to file a police report for her so she can get her items?
No, ma'am.
So he can't do that. So what do you want from him?
I had to do it on my own. So if there's nothing he can help me with, then that's
Well, see, that's the thing. Now, when you're before me and you're looking at potentially going to prison, now you're like, oh, well, he can't help me with that. He's told you that. Be an adult, solve your own problems. This is supposed to be problem solving. That's why you're on probation, for anger management issues, because you can't problem solve. I don't know, maybe you never were taught to problem solve, but if he's telling you, no, he can't do that, that's not in his job description, then there's no need to use profanity against him. He's told you, I can't do it.
Judge, if I could
Yes.
speak for a minute. Throughout my time working with Ms. Holmes, it's been pretty apparent that she has a pattern of not taking responsibility or accountability for her behavior. This last incident just kind of made it painfully obvious how there's a deeper issue.
Mhm.
There's a heart issue. Until she can get her heart right, this pattern of behavior is going to continue for her throughout her life.
Mhm.
And she's going to continue to be a danger to herself, to the community, to her victims, everybody. She needs to get her heart right and realize that choices and actions have consequences, good and bad, intended and unintended, anticipated, unanticipated. And until she gets her heart right and realizes that this is just going to continue.
All right. Thank you so much. And thank you for coming down.
Yes, ma'am.
So you're going to have to start using your cognitive skills and your problem solving. That's it. When somebody tells you they can't do something, then they can't do it. If somebody tells you, no, I can't take you to the grocery store today, figure it out. He is not really responsible for anything outside of his job description. If he does something outside of his job description, that's just probation officers being nice.
And I understand that, but why would you offer to try to help me when I'm asking for some type of help? And then you tell me you can't help me.
Yeah, he said no. Let me just tell you, here's a perfect example. And I've been in situations where people have told me no. And my thing is, I want you to not send me place to place. If the answer is no, just tell me no and I'll figure it out. He told you no. If I ask him right now, like for example, I had to rush here this morning because I don't like being late, and I was filling in for somebody else on another matter. And guess what? My tank is at a 4th. I don't like it being at a 4th. Now, would somebody go, excuse me, could you go and put gas in my car for me? They're going to say no. Now, what do I do with that? Do I use profanity against him? How dare you not go put gas in my car? He's just told me no. So guess what? As an adult, I got to figure it out. That's it. You got to figure it out. And your figuring it out is, let me get angry with somebody and use profanity against them. And maybe they'll then become so afraid of something and say, okay, we'll do that for you. Not his job. And I can tell you right now, if you don't start treating people with respect, one, you're not going to get anywhere, because when you disrespect people, they don't want to help you. And number two,
respect.
No, you did not. That's the thing. You're still in this clouds. Like these are not, I don't know how your relationships are outside of this world, but in this world, you need to treat people with respect, whether you respect them or not. Like right now, you can hate my guts all you want to, but you had better say your honor or judge. You understand? You better not be calling me out of my given name, and you better not be calling probation officers out of your given name. I'm sure he told you, no, I cannot help you. And when somebody says, no, I cannot help you with something, maybe you want to ask them again. You ask them again. If you ask the third time, you're begging. And he's already told you he can't help you with that. That is not his job. That is outside his job description. If he decides to help you outside of his job description, just him being nice. You need to figure it out. The same way people have children, and you figured out how to have children, you need to figure out how to get the rest of your life together. You're on probation because of your actions. And honestly, the reports I received, I will tell you, when I received that report, I told them, file a motion to revoke. And then probation came to me and said, Judge, could we do a compliance hearing to have her come in? And I'm like, yeah, if you all want to do a compliance hearing, we will do a compliance hearing. So this is the last time I'm having this conversation with you, telling you, you need to be respectful to people and you need to learn how to problem solve. How old are you?
33.
You're 33-year-old. You figured out how to get all of those piercings, right? You figured out how to get the nails. You figured all of that out on your own. You need to figure this out on your own. Is there anything else you need from me?
No.
All right. Does she need to, when is her next report date? And are you employed?
You told me I had 30 days to find a job. I had a business, but all my stuff is gone.
All right. So that'll be a no. So Ms. Ferguson, recall her for the week of August 11th, and I'm going to see how you're doing on probation. What date?
I can do that. That's my date, the 11th.
All right, so you're coming back on August the 11th for me to get a report on what's going on. If you'll give her a reset form. Probation,
Yes, Judge.
when is her next report date with you?
It's not, I have an appointment set right now, from Officer Wolf's information. She was supposed to be reporting.
He wrote on the paper July 9th.
Twice a month.
July 9th?
That's what he wrote on the paper.
All right, so she said her next her next appointment date with him is July 9th. All right.
I have to confirm, Mr. Wolf was mentioning that the GPS is supposed to have been installed as well, but that she did not have it.
All right.
I don't have nowhere to stay nor address.
It was ordered June 5th. And it was supposed to be done to work release waive the fees for partial for employment purposes only.
All right, so if you all could give her a list of places for her to find housing. And then we're gonna come back on August 11th, and by August 11th, you need to have the GPS on. All right, thank you.
Good morning. Are you Matthew Wadsworth?
Yes,
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. Yes.
Are there any additions or corrections?
No, Your Honor. Not from this one.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, it's the cap of 8, the agreement, I think it's a cap of 8, and just based on the criminal history alone and the PSI, it looks like
It looks like you did a very good job of getting that agreement.
that's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history. The first page of his, I guess, rolling into this second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000. All one. In January of 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case, he's
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he pointed out by the probation officer in the report, he's indicated that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. Okay, hold on. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight ups, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin. I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them, and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 19. I said, I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it, my truck, my tools and everything, and I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. And we started fighting. I was losing, and I hit him. If you do give me the chance, what I need is some help staying on my meds, because I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying. The problem is you're 51 now, 52?
51.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said, this is
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions. 21. I know. Wow. Right.
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith.
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's pending. Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account to probation where he said the part about the baseball bat is not true. A dresser fell on top of it.
I saw that.
He's still not accepting responsibility.
I hit him with the cane.
Hold on, don't speak over. I let you talk, so don't talk over anyone else, please.
I believe probation is absolutely right that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8 years to DC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. Morning, Ms. Mulkey. Good morning, sir. Are you Devin Keith Byerly? And Mr. Byerly has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800, on probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Yes, ma'am. Judge, obviously I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Byerly. So I know that he's entitled to a bond as he is on deferred.
Maybe he is without certain findings. So that's why we're here. So just also for the record, Mr. Byerly, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they haven't been proven true. But it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense. And that you were at a other location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the board meets.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to, setting a bond? And if I did set a bond, what specific conditions do you think would be?
So I
Helpful.
received his case, I became his officer in February of last year.
Okay.
And since then, I have put him in ISF cognitive, I have put him in JCDI. Prior, he's done an MRT. He tells us that he understands that he has a drug problem, but then still continues to go do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me the reason he would need a bond was so he could go work out of the county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't either.
Can I have?
You may, go
can I
ahead.
ask her a question? When did you place it on JCDI? Do you have a date of when this time? When was he actually placed in? Was it 2019? When he was placed on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
His drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions. And we believe outpatient would be the best for him. He had spoken to me briefly as well that he had some issues he wanted to talk through. He had some family issues he wanted to talk through. So we got him in front of a counselor, him getting the drug treatment is what he needed. He agreed with us, that's what he needed. So he believes that outpatient program is the best option for him.
Did he go to JCDI?
He did test positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDI, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program.
So it was the new offense that dropped him, it wasn't him not going?
As well as the drug use.
Okay. And was there another program too that you said?
He had done ISF, cognitive track.
And what is that?
It is the interesting facility that we send people to, about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else, Mr. Burbank?
Mr. Barrow, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer, and I believe I mentioned also to you that I would like to get into an outpatient program at that rate choice if possible, which will allow me to, I just told you I couldn't work out of the county. The reason why I asked for that was because I'm working at minimum 1,000 hours less than I normally work.
You are a longshoreman, is that
Yes,
correct?
yes, sir, I am a longshoreman.
And the incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir, there is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that
I
you
work
go to.
at, and as far as making my payments and getting back on track, I had a stroke last year.
I'm not worried about your payments.
Yes, ma'am.
You had a stroke last year?
Yes.
And you're still testing positive for drugs after having a stroke.
Yes, ma'am.
Okay. All right.
Issues, that's not an excuse, but that's my daughter.
Do you have a place to stay?
Yes, I do.
And where is that?
Two apartments, Mosaic Apartments is where I live.
Who stays with you?
No, I live by myself.
who would supervise you? Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister, Latoya Byerly, also my mother, Byerly, and uncle, Christopher Williams.
And how far away do they live?
Well, as far as my mother and my sisters, they live in Houston. As far as a good friend of mine, she lives right there in Port Arthur, in Martin Frazier.
Do you have any kids?
Yes, sir.
Where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in, I got two kids here in Beaumont. One that I'm not allowed to see, and then also Tristan, who I just reconnected with Tristan, my 11-year-old.
Mr. Viola, just one last question.
Yes, sir.
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing?
Well, for one,
What guarantees?
I would accept that offer of the patch. And I would guarantee, I just want to get back to work. What I do, I always go to work and come home.
You do other things because you've done other things.
Yes, I have.
So what's the guarantee that says you're not gonna do those other things when you're doing work and going home?
At this particular time, offer my word, even though the past doesn't.
That's right.
Yes, and that's one I told him, I see this as my last opportunity to keep everything that I have in the house. So that's.
One of the things is that you tested positive. What date was that, Your Honor? On
I don't know, Mr. Burbank. What date is it?
Now, I was wondering what date it was on the allegation.
There's a date of April, if I may.
Go
April
ahead.
29th, April
Did you
15th.
test positive for alcohol back on that date?
Yes, I did.
And was there a date also of positive for cocaine? Was there?
Yes.
Yeah, there was. So those allegations are true, correct?
Yes, I did.
If the court is not considering a bond and that he needs help, he has pled true, Your Honor, to testing dirty at this point.
Well, he hadn't pled. We're not sworn in, or, I mean, if he wants to plead to the motion, we can take care of that. With regard to the bond, the allegations, at least for that new offense on May 29th of this year, is that approximately 3 o'clock in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you allegedly. My fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after this is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his probation. Let's work with them. Let's work with them. Let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest in these cases of our community. I am going to leave it at no bond in these cases. We can handle this a couple ways. We can go through the motion. We can get pleas of true or not true. We can set it for a hearing for sentencing. If, depending on what the plea is on the, excuse me, the new charge of possession, we can get with the lab and I can ask them to get that done before that hearing. We can take care of that at that hearing.
Right, I I'm advising not to enter a plea in reference to the new offenses until we know exactly what it is. On the
That's fine.
assault, there may be a question
I
on
think
that.
we can get that taken care of, if I make that special request that they get that done in time. Do you want to go through the motion today?
Besides the new offenses, yeah.
Well, I'm gonna go through the whole motion. He can enter pleas of true or not true.
Okay.
Mr. Byerly, raise your right hand the best you can. Excuse me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, let me get this pulled up a different way. I think I can do it. So will he waive the formal reading of the motion?
You will, Your Honor.
It's mine, Judge. I'm trying to turn it off.
Mr. Byerly, in 18-28800, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, and that was a 10-year deferred probation for violation of a bond or protective order. And is that correct? And then in cause number 18-29063, that's what I need, thanks. Perfect. I also have a first amended motion to revoke your unadjudicated probation. It also shows that you were placed on probation May 13th of 2019 for the offense of violating a bond or a protective order, third-degree felony, and that was a 10-year deferred probation. Is that also correct? They, both of these motions allege that you violated your probation. Count 1 alleges that you committed the new offense of assault April 21st of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates, and is that true or not true? Count 3 alleges in each case that you failed to provide verification of attending the JCDI program as ordered. Is that true or not true? Well, he was attending, but you were discharged. So I'm going to put not true to the way that one is worded. Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances and that you provided a sample that tested positive for alcohol April 15th of 2025. And is that true or not true? Speak up, please. Count 5 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true? Count 6 alleges that you possessed a drug, crack cocaine, May 29th of 2025. Is that true or not true? Count 7 alleges that you were at a location other than your residence at approximately 3:19 a.m., May 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2, 4, and 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 2, 4, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, ask probation to do an updated pre-sentence report, ask the state to bring any witnesses with regard to those other cases. We will set it at 11 o'clock probably, but we don't need a bunch of time, do we, on a regular day? We'll just do it at 11 o'clock. And if you need me to call the lab for any reason to make sure that that gets done as quickly as possible so that Mr. Burbank has notice of those results, then just let me know and I'll help take care of that if we can get that expedited. All right, we'll see y'all back at sentencing. Yes, sir, thank you. Give me just a second. Well, I had it up here and I had other stuff here. I had some of it. It's hard to have them both pulled up and. Okay, yes, ma'am. What was it, 2, 4, and 7? He pled 2, 4, and 7.
All but the new allegations.
Yeah.
Possessions of assault.
Got it.
Well, the 2 allegations of it. And then there was one in reference to JCDI.
Got it. 2, 4, and 7.
Wasn't-
All right, Brandon Dodd, Mr. Burbank. Good morning. Are you Brandon Dodd? And this is 242418. Mr. Dodd is charged with murder. And Mr. Burbank, what is the announcement?
We have been, as you know, I'm the second, or maybe third attorney, judge, second attorney on this, just retained. I'm just asking for one more reset. We're almost up to speed. There were some questions I've gone over and talked at length with Mr. Dodd and just requesting more time. There is a co-defendant, but that didn't make no difference.
Okay.
No objection, Judge.
All right. And so what I'll do, yeah, it looks like you've just been on it a short amount of time. Mr. Dodd, I'm going to reset your case one more time so you and Mr. Burbank can make sure you're both up to speed on everything that he's got, negotiations, and then we'll see if we can get an announcement at that next court date. All right. You can go back with the bailiff. See, is Mr. Gertz? Yes, sir. Thank you. Mr. Kimler. Mr. LeBlanc, you've got Linton Arsenault. Did I pass my, I hate that. I get those, it was one of those tickles that wasn't getting. I know, I've got water and it's just one of those that gets you. Yeah. Good morning, sir. Are you Linton Arsenault? And this is 242190. Mr. Arsenault is charged with failure to comply with sex offender registration requirements. Mr. LeBlanc, what is the announcement?
Judge, I've gone over everything with him, and we've talked, I need to talk to Mr. Honkpower regarding it, I believe it's gonna be something we'll have worked out.
You believe it'll be what?
It'll be something we have worked out, I think.
Okay. And Mr. Hoffpower is out this week, but he'll be back next week, right?
Yes, Judge, and Mr. LeBlanc did come and get the media.
Okay.
For this case as well.
Good.
I just have not discussed the offer with him. I'm happy to
Sure.
do so.
So what I'm going to do, Mr. Arsenault, is reset your case one more time, and it'll be that last reset. That'll give Mr. LeBlanc time to talk to the district attorney's office, make sure whatever offers they have, any negotiation is complete, make sure you've seen everything they have, and then we'll get an announcement at the next court date. Okay? Thank you, sir. You can go back with the bailiff. Thank you, Mr. LeBlanc. I don't know. I mean, I'm not opposed just because he would have to do all of that. And I want the new case indicted and part of the deal, not just to go away.
Right.
You know what I mean? I think.
It shows the lab is already in progress, so we'll just stay the course. And
I mean,
see
that's
where we
clearly
get
what he
with
needs. So I'm not opposed to it, but he's gonna have to take some responsibility for all that.
Okay.
Yeah. Let's see, Mr. Matuska, you've got Xavier Garner. Good morning, are you Xavier Garner?
Yes, ma'am.
And Mr. Garner has 4 cases, and 230957, harassment by a person in a correctional facility, 242322, aggravated sexual assault of a child, 242323, and 2324, indecency with a child. And Mr. Matuska, what is the announcement?
Your Honor, I've been able to collect most of the discovery. Still trying to get some of the digital media. I do expect this case to be placed on the trial docket. I just need to get the digital media.
Okay.
I've talked to Mr. Nichols about that, and should be shortly.
We did speak, Your Honor, but I've been out the last few days, so I wasn't able to get that resolved for him this time around.
Okay.
I think it shouldn't be hard to get it for him, make sure he has everything.
Okay, so I'll do one more reset, and this will be the last reset. Y'all make sure you visit about all of that. Mr. Garner, what I have here is a pile of jail incident reports. So I want you to make sure you know that I know everything you're doing in court. And if this goes to trial, a jury will know everything that you're doing in our jail. Do you understand that?
Yes, ma'am.
You're fighting, you are talking back in an extremely ugly way to the correctional officers who are just there trying to do their job. That's their job. They're just going to work every day. They don't need to hear this crap from you every day. Every single day you're talking back, you're calling names, you're not following the rules. You want to do it your way. When you're in jail, you don't get to do it your way. And if you do continue to do it your way, you're going to end up with another harassment of a public servant in a correctional facility. You're going to end up with more time if you get found guilty because a jury's going to be mad because they're going to hear about all these things. So I want you to stop and I want you to understand, and I've been telling every one of you, how old are you?
22.
22 years old. It's all of you young kids out there acting like absolute heathens. So if you want your life to get better, you tell the rest of them, hey, I'm not going to get in trouble anymore. Y'all do what you're going to do. But running up on people, stealing their food, calling names, it's only going to get you in more trouble. All right?
Yes, ma'am.
Go back with the bailiff. And we reset Ms. Broussard for Mr. Nix, correct?
Yes.
Mr. Rennick, you have did I see Mr. Rennick?
Yes.
We're working on it.
Okay.
He's got something. But he's still.
Mr. Joel here? What about
Mr.
Mr. Vasquez, are you ready to announce on Veronica Randall?
Can we hold on that, Your Honor?
Sure. Okay. And what about Mr. West? Mr. Rojas, are you ready on Lawrence Jackson?
I don't think we need to ask for a reset on him. He wants to look at the videos on that new DWI.
Okay. And you've already got them? You just need to go out there and visit? Okay. We'll just, on Lawrence Jackson, we're going to reset Lawrence Jackson for you to go show him those videos, and we'll get an announcement at the next one. Thank you. Mr. Parker, you have Cortland Pender.
I don't know, well, I don't know if we need him, Judge. I think Mr. Coleman's gonna confirm that, there's 3 cases in the motion that have been, my client thinks they've been dismissed, and I think if we can reset 1 week to confirm
My
that.
understanding is that they're out of Dallas County doing it, so sometime.
Okay.
It's a week from now.
Let's do.
Oh, yeah, of course.
Do you want to, how are we next week on? I don't know, the next week maybe just as, all right, let's just do 1 week on Cortland Pender. And then you've got Esker Boykin, Mr. Parker?
We have a play ready.
Okay.
Well, you-
Oh, that goes in that other file I was, okay. Did we already do something on this? And then
He was evaluated. We started to,
started.
and we chose to have him evaluated.
Okay. Good morning. Are you Esker Boykin Jr.? And this is 250351. I'm going to take judicial notice of the court's file. Mr. Boykin was examined by Dr. Papon for competency to stand trial. I received that report dated May 21st of 2025. The finding in that report is that Mr. Boykin is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Mr. Coleman?
Not from the state, Judge.
All right, then at this time, I am going to find that Mr. Boykin is competent to stand trial. Mr. Parker, will he waive the formal reading of the indictment?
He will, Your Honor, and just for the court's record, please do it lesser included.
Thank you, I see that. All right, so Mr. Boykin, in cause number 25, DCCR 0351, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that is from March 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind. Do you understand?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Did you have something? No. I'm sorry. All right, Mr. Boykin, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor assault. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. Veronica Randall, Mr. Vasquez, Ms. Malfino.
Good morning.
Good morning.
Thank you for smiling.
Good morning, ma'am. You're Veronica Randall. And Ms. Randall has two cases, 250246 and 0247. Both are theft of property with previous convictions. And Mr. Vasquez, what is the announcement?
Judge, could we ask for a short reset? I need to, Ms. Malfino's made a reasonable offer, but I need to do some research in Ms. Randall's case.
All right, and
Judge, I think this is Mr. Vasquez's first setting on this. Previous
I
setting,
see
you
that.
asked me to kind of map the indictment. It's so many priors that it almost makes you cross-eyed.
yes,
I think we just have a friendly disagreement on what level it is. The offer as I have made for 4 years, TDC would be valid if it was either a third or a second. Mr. Vasquez's position is that it's a state jail. I will go back and look at it again. That is not my position. I will have another set of eyes on it, because like I said, it's so much, it gets tangled up, but.
And Your Honor,
Regardless, I think it's at the very least a third, if not a second.
thank
Okay.
you, Ms. Montana, for your explanation. I'm sure I'll be in agreement, Your Honor. I'm just not certain right now.
Okay.
And I'm supposed to know these things.
No, that's okay. So what I'm gonna do is one more reset. This will be the last one. Y'all take a look at all of it and all the priors and get that worked out. And then we'll get an announcement at the next court date. Either it's gonna get worked out with the plea or it's gonna go in the trial docket. So Ms. Randall, I want you to know that I receive jail incident reports. So everything that happens out at the jail, I get a report of. The assistant district attorney gets it, your attorney gets it. If you want me to accept any plea agreement later, this behavior needs to change. If you go in front of a jury, they're gonna see these things. So you've got to follow the rules. If you want any benefit from any of us or a jury, you've got to show us that you can follow the rules and not continue what you've been doing in that jail. Do you understand? You're too old for this behavior. Right? A lot of times I'm having this conversation with my 18, 19, 20, 21-year-old boys. That's who's acting up in the jail. Not you. All right? So stop this because everybody's going to know what you're doing. All right? Okay. We'll see you at the next court date. You can go back with the bailiff.
Joel, 2 weeks.
Thank you, Your Honor.
2 weeks ago, I just popped up on my phone.
Awesome. Good for him.
Sorry, I don't.
Philip,
2 weeks. Oh, here. Sorry.
I'll just tell him. See, Mr. Lewis, you have Jacqueline Young, 3 cases. Looks like you got pleading on 2, correct? Thank you. Oh, that's what I spent my afternoon doing yesterday, was reading jail reports. I spent more time on jail reports than I did PSIs.
They're more voluminous.
Same names I keep saying. Let's see, so we are going on the MTRP in 1 new case. Let's go with this new case, 25. Good morning, are you Jacqueline Young? And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Mr. Young, in cause number 250309, you're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me. When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions, just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you? Are you? Okay. Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation, I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not gonna let you guys negotiate. That, I don't have to do that legally. So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So, again, before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 21-37857,
Your Honor, it's a second amended, just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13, 13 being the offense he's already pled to.
okay, let me look at it. Thank you. I got it, thank you. So I have a second amended motion to revoke your community supervision. So you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And
Oh, it was
count 20
run.
reads motor vehicle, that's incorrect, Judge. It's evading on foot
Okay.
with priors.
Okay, gotcha. And so this shows that you were placed on probation August 29th of 2022 for evading with a vehicle. And that was a 10-year sentence in prison that was probated for 5 years. Is that correct? And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true? What's the status of the possession and the failure to ID from that date?
I believe the failure is, I think, still pending. The misdemeanor.
The failure ID is still pending next door, Judge.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay.
I will double check and see if there's, I didn't see anything else like filed or pending. At this point, I'll check and see if there's a lab report pending, but I don't think that's been filed.
Okay. Let me look at something real quick. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing. talks about the allegation of his behavior to, it looks like there was something that happened with probation. One of the allegations, so I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my. Same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail. Do you really think that your probation officer is going to go on a date with you? Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail. Cursed loudly about the work you had to do for your community service, calling it slavery. You think community service is slavery? Do you think that? It's the same. I'm not taking 5 on the MTRP. I've already taken 5 on the other. Y'all can renegotiate or you can let me do it. So I'll hold everything right now. Y'all go visit some more, but that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different, but I'm not gonna do that. Let's see, so I already did that one. Okay, great. There goes something else probably going out to everybody. Now my computer's stuck. Are they? It just, yeah, it's not letting me do anything. Oh, it just let me do something. But I thought I sent this one to you. Let me double check why it didn't go. So that one's done. Did I print out the certification on 0309? Do you see it? Here, I'm printing it out now again, just in case I can close it. Because I did already do that one, so. All right, so what about Mr. Lou? Oh, is he back there? Let's see. I'll skip that one and go to Ms. Holmes. You got a Prestavian Westbrook. Are you ready on that?
Can I get a minute on that? I'm ready on.
What about John Wade? It's a sentencing. Let's get John Wade.
Let me get my tab.
Oh, good. One that doesn't have any issues.
I've got a check mark on mine.
Huh?
I've got a check mark.
I do too. And it's so nice to see that. We're talking about how nice it is to see that on the front of ours instead of all the colorful markings, the rainbow markings. Good morning, sir. Are you John Wade?
I am.
And Mr. Wade was previously in court, entered a plea of guilty to evading detention with a motor vehicle. This is cause number 250027. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, sir.
Are there any additions or corrections?
Not from the defense, Your Honor.
Not from the state.
All right, Mr. Wade, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is dismissed. You'll never be a convicted felon. The other side of that is if you violate any conditions of probation, you can be brought back into court. You could be convicted of the offense and sentenced to prison for up to 10 years. Do you understand?
I understand.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Thank you much.
Yes, sir. Jamie Story.
Yes. That, yeah.
Jamie Story.
I'm just gonna enter, please.
Okay.
True.
And set it for hearing?
Yeah.
Okay.
Well, I think it's just, I think she's not contesting it. I just think we probably need the court to maybe determine the amount of time
Okay.
on the revocation.
We'll get an updated report. Okay. You would think that word would start getting out there about the behavior and that there's actual consequences.
Wait till our next one, it's gonna be about 17 pages.
Oh, yeah.
And I just chewed him out back there. So
Well,
yeah, he's prepared.
he's Good morning. Are you Jamie Story? And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Story, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, ma'am. You can put your hand down. And this is cause number 23-1546. And in that case, Ms. Story, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the offense of theft of property, a state jail felony, and that was, and I guess there must have been some priors as well because it was a 10-year sentence that was probated for 10 years. Is that correct?
I noted back in May 24, she pled to the full indictment, which made it at that point to third degree.
Thank you, Ms. Malfino. The motion alleges that you violated your probation. Count 1 alleges that you violated that because you failed to report to the probation office as ordered February 28th of 2025. And is that true or not true? I'm sorry, speak up, please. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your contact information. Is that true or not true?
True.
Okay. Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? Count 5 alleges that you failed to complete the mental health evaluation and follow any recommendations of that. Is that true or not true? Count 6 alleges that you failed to provide verification of completing the theft prevention class. And is that true or not true? And then finally, count 7 alleges that you are behind in your court assessed fees just by $100. Is that true or not true? Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for a sentencing hearing. Ask the probation department to do an updated report that'll give me more information about what's been going on while you've been on probation. Anything that you think is important for me to know, get that information, excuse me, to Ms. Holmes, and she'll present it to me on your behalf when we come back. I did that in like 2 last night. Okay. It's unagreed, yes, ma'am. Let's see, Miss Holmes, you have Stephanie Martin.
Judge, I'm working on the paperwork. The tablet is.
Okay, I'll hold that until that's ready. Thanks. And Daniel Martin, is he in, is she in the back? Is Miss Holmes working on something in the back?
She was in the back.
On Daniel Martin?
Yes, Your Honor.
You good over there?
Yeah.
Do y'all need a minute?
So, can you go off?
Uh-huh. Jamel Caddy, Ms. Holmes.
We could hold that one.
I'm gonna hold it. Christopher Bushnell? Oh,
Yes.
yeah. Christopher Bushnell.
And we came back for sentencing, and my notes say you rejected it.
Okay.
So there is a yes. So they were expecting. I guess so. I must have forgot to. My notes say everywhere that you rejected.
Oh, yeah.
But it doesn't matter. I wrote that.
Oh, okay. All right, you're Christopher Bushnell? And so Mr. Bushnell has two cases, an evading arrest or detention with a motor vehicle and engaging in organized criminal activity, and cause numbers 25-0112 and 0113. There was previously an agreement, motion, I'm sorry, and a plea agreement for 10-year deferred probation. We were here because of the issues in the jail. I rejected that because if I were going to go along with that, I was going to order the ISF. And so we're back here. And then, so let me ask you, I should tell you what's bad is when I remember stuff, Mr. Bushnell. Your birthday's in October, right? No, December. So, so we're getting close, but here's the problem, Mr. Bushnell. So you were here May 6th, right? And I didn't accept these plea agreements, and I got pretty upset with you because of what had been going on in jail, right? And what did I tell you?
Back with no write-ups.
You know how many write-ups you've gotten since May 6th? You want to take a guess? Too many to count. Too many to count. May 6th, you got, since then, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 more. Fighting, same things. Fighting, not following the rules, calling names. I mean, same thing. You don't like following rules, do you?
I do.
You do? What part of calling a correctional officer the names that you've been calling is appropriate? It's not. So why would you keep doing it after I told you? I told you, go just be good for a month. 1 month, be good, follow the rules. And it's one thing if you've got another inmate running up on you fighting and that was your excuse, but it's not. I'm not accepting any plea agreements. If the jury wants to see all this and give you probation after that, that's gonna be up to them. I'm not doing it. Go back with the bailiff, we'll set your case for, well, let me do this. Ms. Holmes has been appointed as your attorney, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. What I can do is release her and appoint a new attorney who can begin preparation for trial. Do you want me to do that? Or do you want to keep Ms. Holmes? All right, Ms. Holmes, get ready for trial. And let me tell you what you're doing. You're making her job hard. She's trying to help you. I wanted to try to help you. If you came in today and didn't have all this nonsense, I'm looking at it over and over, calling them the B word, not doing what you're supposed to, saying, I don't care, write me up, I don't care. If you don't care, then I don't care. Because I tried last time when we had this conversation. So your case is going on the trial docket, and again, we'll let a jury decide what to do with you. Go back with the bailiff. Good luck, Ms. Holmes. Chad Holland, Ms. Minaldi. Is that a plea?
Yes, it
Okay,
is.
as soon as it comes through, I'll take care of it.
Thank you.
It's not here yet. Thank you, ma'am. Mr. Kimler, you have Marissa Tibbetts, 3 cases.
That's gonna be a plea on the 2 and 4 that you're saying violation.
Did you do paperwork?
I haven't. There's no agreement.
Okay. Please, I guess that would be easier.
Sure.
And what about the new case?
That's part of the NCRP, just carry it with the NCRP. I think there's a non-prosecution. I don't want to speak to the attorneys, Mr. Smith's case, but I think he's going to communication with the victim or his office is.
All right, hold on a second. Mr. Smith, on Marissa Tibbetts.
Yes, ma'am. Did Rod tell you on these, we're just gonna go through the motions?
Yes.
Through the motion.
And I would think, well, there's 2 motions.
Yeah, through the motions.
And then I would assume, is your intention to prove up the other one, or is there some issue?
If we can, I need to get hold of the.
So we'll set it for a time when there's a little bit of time then?
Just a little bit.
So a regular docket day, or maybe somewhere where you have a little more?
Short docket.
Good morning, are you Marissa Tibbetts?
Yes, ma'am.
And will your client waive the formal reading of the motion in each of her cases?
She would, Your Honor.
Okay, Ms. Tibbetts, in cause number 1828, well, before we do that, raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Ms. Tibbetts, excuse me, I have in cause number 1828754, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2018 for the offense of aggravated robbery, a first-degree felony, and that was a 10-year deferred probation. Is that correct? And then in cause number 1828753, I also have a motion to revoke your unadjudicated probation. It shows you were placed on probation October 29th of 2018 for aggravated robbery, a first-degree felony. Again, that was a 10-year deferred probation. Is that correct? Each of these motions allege that you violated your probation. Count 1 in each motion alleges that you committed the offense of burglary of a building March 22nd of 2025 in Jefferson County, Texas. And is that true or not true?
No, ma'am. Not true.
Count 2 in each case alleges that you provided a urine sample March 18th of 2025 that tested positive for methamphetamines and marijuana. And is that true or not true? True or not true?
True.
Count 3 in each of the cases alleges that you were at a location other than your residence at 11:15 p.m. March 22nd of 2025. And is that true or not true? I'm sorry?
Not true.
Okay. Count 4 in each case alleges that you are behind in your court assessed fees, and it's just a little bit in each case, $29 in one and $37 in the other. Is that true or not true?
Yes, true.
Did you enter your pleas of true in each of the cases to counts 2 and 4 freely and voluntarily? The counts that you pled true to, 2 and 4, did you do that voluntarily?
Yes, ma'am.
And did you plead true to those counts because those 2 are actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true, find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your cases for a hearing. The state on that date, if they want, can put on evidence with regard to any other allegations. And anything that you think is important for me to know, get that information to Mr. Kimler. He will present it to me on your behalf when we come back. I'll also get probation to do an updated report as well. All right, you can go back with the bailiff.
Your Honor, if I may, this is deferred. I think the court has set bonds in the cases that are relatively high. I believe they're.
Do you want to file a motion for, if I've already had a hearing with another attorney, I don't, unless there's some change of circumstances, I don't, we're not going to do that today for sure. But I would need some change of circumstance if I've already had a hearing.
When the reset is, can we get a speedy reset?
You're going to get the same reset on a motion that we get so that everybody can get prepared and so that that updated report can get taken care of.
I'll be out to see you.
Print.
Just at 11. What? Yes, ma'am. Yes, absolutely. So another one at 11, I know. And there might be, you know what, if we're loading those up at 11, there might be a week when we're not, just, let's look at it, because I can set it on at 1 on a week when we don't have a jury also, you know, so that we don't load up or have to put it too far off. So just make a note, we can look at it if you think that's, okay. Let's see, what else was Mr. Lewis? Mr. Lewis, on Brandon Chillo, what are we doing on that? Are you ready? That's the MTRP sentencing. Nope, I'm doing it. I just did it. I just did the. I know. You can tell when it's. Morning. How are you?
Good.
Good. Good morning, sir. You are Brandon Chillo? Yes, ma'am. And in cause numbers, or in cause number, I'm sorry. Is there 2 cases? Yeah. 19-32403 and 19-32404. Mr. Simon, good grief. Sorry, Miss Simon. Mr. Chillo is on probation in each of those cases, was here previously and entered pleas of true to motion to revoke probation to counts 1, 2, 3, 5, and 7. I've received an updated report, and has everyone had an opportunity to review that report?
Yes.
Any additions or corrections to that report?
Nothing to finish.
Judge, the only thing I have is in speaking with Mr. Hoffpower last week, it was not his position, I don't believe, to put on any additional evidence because of the fact that Mr. Chillo pled true to count one. The others just kind of actually patterned that, and based on Ms. Simon's recommendation of continuing him on probation with JCDI. We don't have evidence of that. If the court needs it, we can get it. But I don't
No,
believe
are
that
y'all
case
in
has been
agreement
filed.
with that recommendation,
As long
Ms.
as
Muffino?
Ms. Simon is.
And Ms. Simon, that's still your recommendation? You believe that, it looks like for the most part, Mr. Chillo, you've been doing everything you're supposed to, especially on the type of probation you're on, which is great, and that gives me less concern, but it looks like there have been some issues specifically with some drug usage that you need some help for, and probation is willing to give you that help and keep you on probation. I want to make sure you understand if I go along with this today and continue you on probation, and if you violate again in any way, it is probably not going to go as well as it's going to today. Do you understand?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, 5, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation in each of your cases in order that as a condition of that probation, you enter and successfully complete the JCDI program. You will be on the high medium caseload, so you're going to be going to probation more often. You're going to be going to JCDI. If you test positive, if you continue to violate in any way, you're going to be back in here, and again, we're not going to have such a nice conversation. Do you understand?
Yes, ma'am.
What you're on probation for is extremely serious. I appreciate that you're doing that part of your probation well, but I want to make sure you know you have to do all of it. Okay?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you.
Thank you, Ms. Simon.
Thank you, Jim.
Thank you, Mr. Lewis. Let's see. What about Jacqueline Young? Did y'all talk?
I just got word, let me check on that.
Go ahead. Okay. And Ms. Minaldi on Chad Holland?
Chad Holland.
Good morning, Judge.
Good morning, ma'am. How are you?
I'm doing good.
And so we're going on all of the,
Just paragraphs 1 and 2, Judge, we're increasing it to a second degree felony for the range of punishment.
okay. Let me get that pulled. Okay, thank you. Good morning, sir. Are you Chad Holland? And Mr. Holland, Ms. Minaldi's here. I know she's visited with you this morning on behalf of Mr. Gertz. Are you fine going forward with your plea this morning with Ms. Minaldi? Thank you. And will your client waive the formal reading of the indictment?
Yes, Judge.
Your Honor, for the record, the state will proceed on counts 1 and 2, and will abandon the remaining enhancement.
Thank you, Mr. Coleman. Mr. Holland, in cause number 24, DCCR 1616, the state is elected to proceed on counts 1 and 2. Count 1 is the offense that you're charged with, which is fraudulently securing a document by exception, or by execution, and that's from December 30th of 2023. Count 2 alleges you were previously convicted of burglary of a habitation March 15th of 2004. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Minaldi? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Holland is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of fraudulently securing documents by execution. Also find that prior offense true. Sentence you in accordance with your agreement to a term of 15 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Minaldi or Mr. Gertz. Do you have your discovery certification?
She gave it to me, I'm sorry.
Okay, all right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Minaldi. Yes, ma'am.
Thank you.
Excuse me, Judge.
Yes, sir.
We have to do it for you.
Okay, and are y'all good with just me making a modification on what I've got here?
Right.
Let me find it again. All right, let's get Mr. Young back out. All right, so we are back on the record in cause number 21-37857, and again, you're Jacqueline Young, right? And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the?
The new agreement is 8 years TDC.
All right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, Your Honor.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them, that the state's marked as exhibit number 1. And before you signed these, did you go over them with Mr. Lewis? Speak up. And do you fully understand them also? And I have made the notation with everyone's agreement on the agreed punishment recommendation page that that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank you.
All right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct?
Yeah.
Okay. It can still go worse. I mean, I got 2 more years. It's not, I mean, it's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself, you know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before. All right, good luck to you. You can go back with the bailiff. I need some sharing time. I did it again. Y'all have got to make me stop. I just did my mouth thing again. My frustrated thing that they keep catching me on. I can't help it. It's what I do when I'm frustrated. Look, my face is turning red right now. They don't have one. I know, it's terrible. I feel like it's the worst. I need something that makes it higher.
I agree. I wonder.
They make these little tripod things. I think I need one of those. If we're gonna continue this, and maybe we can move it over a side or something. Okay. Let's see, Mr. Rennick, are you ready on Tyron Henderson? There's no paperwork on that one, correct? Oh, yes, there is. I see. What? And did y'all do paperwork on the MTRPs? Oh, I don't have all that. Let's hold it for a second. Okay. Well, it's 3. It'll take a second. Let me keep looking at what I got here. Mr. West, what about Mr. St. Clair?
I'm doing a rejection right now, and I'll have that for you in a second.
I'm gonna need, yeah, for sure the MTRPs, all 3 of those.
There's one new offense charge.
Yeah, I don't need the new offense one, but thank you very much. All right, Tyron Henderson. Thanks. That's Jacqueline. All right, good morning. Are you Tyron Henderson? And will your client waive the formal reading of the motions and the indictment?
Yes, Your Honor.
Just a second. Oh, hold on, I'm pulled up the wrong one. Go paperless, they said.
I remember in the old days, we just wrote it on
I would have
paper.
already been done.
Yeah.
All right, Mr. Henderson, in cause number 25, DCCR 0520, you're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from March 23rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rennick? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for a 10-year term in prison, but that would be probated for 10 years. Is that and it would run,
That's an error, Judge. That's an.
there's no
NPRP.
concurrently,
Yeah,
okay.
there's no.
So, I'm gonna mark that
Yeah,
out.
that was my mistake.
And then I guess the agreement then on the others is to continue probation.
With ISF cognitive. That was actually all of the judge.
Okay. Oh, this one as well.
Yes,
Can I make that notation?
Yes, please, Judge. I apologize. About
So the agreement is also, if I follow it, that you would enter and successfully complete the cognitive track of the ISF program. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Henderson is not competent?
No, Your Honor.
All right, Mr. Henderson, in 250520, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. I am going to reset your case for sentencing. I want to get some more information about what's been going on and get an updated pre-sentence report, find out more information about this case and also what's been going on probation, and we'll come back later for sentencing. And can you double check? I don't see any, so I'm assuming there weren't any. If you didn't give it to me yesterday. It's perfect. We'll talk about that in a second. All right, then, Mr. Henderson, in cause number 21-38934, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation August 1st of 2022 for the offense of evading arrest with a vehicle, and that was a 5-year deferred probation. Is that correct? Answer out loud, okay? And then in cause number 22-39131, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 1st of 2022 for the state jail felony offense of unauthorized use of a vehicle. That was also a 5-year deferred probation. Is that correct? And then finally in 23-0899, I have a motion to revoke your community supervision. This shows that you were placed on probation November 27th of 2023 for theft of a property, state jail felony, and that was a 2-year term in the state jail prison, probated for 5 years. Is that correct?
Yes.
Each of these motions allege that you violated your probation. Count one in each of these motions allege that you were arrested for the offense of evading arrest or detention with a vehicle March 23rd of 2025. And is that true or not true? Count 2 alleges that you were arrested for the offense of reckless driving March 23rd of 2025. And is that true or not true? Count 3 alleges that you have not provided verification of performing the community service hours as required. Is that true or not true? Count 4 alleges that you were at a location other than your residence at approximately 3:35 a.m. March 23rd of 2025. And is that true or not true? I think I'm going to keep going. I've got some concerns on this. Count 5, thank you though. Count 5 alleges that you did not provide verification of complete, well, hold on a second. Count 5, oh, they're different. Count 4 in 2 of the cases and count 5 in the other alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? And then count 6 in each case alleges you're behind in your court assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1 through 6 in each of these motions freely and voluntarily? And did you plead true to those allegations because they're all actually true? In each of these cases, I also have some documents here on the computer that have your signature on them that the state's marked as exhibit number 1. Did you also go over all of these with Mr. Rennick?
Yes.
And you fully understand them? And it looks like the agreement in all of these is for me to continue you on probation and order that you enter and successfully complete the ISF cognitive track. Is that your understanding?
Yes.
State tenders number 1.
There's no objection.
It's admitted. Is there any evidence again that Mr. Tyron's, Mr. Henderson's not competent?
No, you don't.
All right, Mr. Henderson, in each of these cases, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty in 2 of the cases and revoke your probation, and then revoke your probation in the other case. But I'm not going to do that. I'm going to reset your cases for an updated pre-sentence report, and then we'll come back at a later date to see if I'm going to accept these plea agreements or not. I do have some current concerns, obviously, I'm sure y'all know. I mean, we've got 2 felony probations from 2022, and then that theft, was that committed while he was on probation?
It was.
It was from prior?
It was prior, he had stolen the dirt bike, I believe, Judge. And that's what all these are involved, the dirt bike.
But one of them wasn't indicted till much later? So we've got the 2 cases, the evading arrest and the unauthorized use of a vehicle. Those are both from 2022. Then we've got a theft of property from 2023 that he was put on a straight probation for. So we'll get it all figured out with the pre-sentence report, but it looks like.
That was a tailgate that was stolen from Granger Chevrolet in Orange, but he helped in recovering that.
So he was on,
It was
so,
indicted later.
but it was an offense, when was the offense date? That would be 23, I mean, well, no, that's the indictment date.
February 2nd of 23.
Okay, so on 2 felony probations, committed another felony, got an opportunity, now we have another felony. So I want to see what all's been going on before I accept these plea agreements. I can tell you one thing that you are doing good and that I hope you continue to do, unlike everybody else probably around you and wherever you are, whichever dorm you're in, is I don't have any incident reports. On paper, it does not look like I should give you this opportunity. If you continue to do well, you have a much better chance of me going along with what they've proposed to me to do, all right? Okay, go back with the, yes.
To his credit, we're actually here to make arguments. He's acknowledged to me the entire time, and realizes that he is not doing what he's supposed to be doing. He's betrayed the property, and he wants to change his ways.
Thank you, I appreciate that. Okay, we'll see you back at sentencing.
Are we doing a test on the new case also?
Please, ma'am, yes. Like I'm gonna start giving good deals if they can just behave. Okay. Stephanie Martin has a bunch, so if y'all want to start printing her stuff, I can.
But they're good, yeah, they're fun, they're fun.
Mr. West, on Aleem St. Clair, do you see something on him? Can y'all check for some rejections? Oh, okay. Let's take care of Aleem St. Clair, please, and then I'll take care of Miss Martin. That'll give y'all a minute to get those.
Sorry I was late, Your Honor, this morning, Your Honor. I was over in Orange, and I let Anna know that I'd be
Thank you,
late, but I
yes, sir.
would be here.
They did, they let me know.
Okay,
Thank you
good.
for letting us know.
Good. Said I don't like to.
All right, sir, let's see, Miss Malfino, this is Aleem St. Clair.
Sorry, Judge.
That's okay. Good morning, sir. Are you Aleem St. Clair? Are you sick? What's wrong with you? When? Okay. Like you're, all right. So, Mr. St. Clair, in cause number 23, DCCR 1390, You're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2023. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 23-2117, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand that as well? And then in cause number 23-2044, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. Again, that has the same punishment range if you're found guilty, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yes,
And then finally, in cause number 23-2043, you're charged with unauthorized use of a vehicle, which is a state jail felony offense. And that is from July 11th of 2023. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
yes, ma'am.
In each of these cases, I have here on the computer some plea bargain rejections that you have signed with Mr. West that shows that the district attorney's office has made an offer. So is it, what's
Judge,
the?
what it would be a 25-year cap in both of the aggravated robberies. We had offered or discussed to dismiss that aggravated assault based on a plea in those ag robberies, as well as the UUMB. We rejected that. We went ahead and did a rejection of a 20 cap in the aggravated assault. But it was my original position to dismiss two, and if he would accept responsibility in the 2 aggravated robberies, and also not to proceed on his 3 misdemeanors. If I may, just for the record, so Mr. St. Clair is aware, now that he has rejected this, unless circumstances change, which I'll bring to the court's attention well in advance, it will be my position to ask that the sentences run consecutively.
So, Mr. St. Clair, I want to make sure you understand. It looks like what you have signed with Mr. West shows that the state's offer was for you to, if you wanted to enter a plea of guilty to the aggravated robberies, for a cap of 25 years, which means you would be leaving your punishment up to me. I could sentence you to 25, I could sentence you to less. It would depend on the information that was brought to me at a sentencing hearing. And the agreement would have been to dismiss the unauthorized use case, as well as that aggravated assault case, as well as some misdemeanors. If you go forward with trial on these cases, we'll go depending on how this all goes, because the offense dates from the aggravated robberies and they're to the same dates, but then that aggravated assault and the unauthorized use are from a different date. And what that means is that if you're convicted on those cases and sentenced by a jury, I could then stack those punishments on top of each other. And I don't know if I would do that or not. It would depend on the information that I saw during those trials. Do you understand?
Yes, ma'am.
Do you want to reject those offers and have all 4 of your cases set for trial?
Yes, ma'am. I'm trying to get a lower offer.
Pull that down a little bit.
I said I'm trying to get a lower offer.
So here's the thing, we're not negotiating anymore, okay? The offer, Ms. Malfino just stated that the offer is what the offer is, and unless there is some new information that is received after today, I will not accept this offer after today. So today's the day to either accept this offer, or your cases will go to trial, or it will be to some offer that's different, higher, or to me open, unless there is some, again, new information that no one knows about. And is there any reason to think there would be any new information?
No, Judge, and what my position was in offering the cap that Mr. West and I discussed was to allow Mr. St. Clair to ask the court for probation. I think that's what he's trying to say. That's what he's been trying to say through his attorney. I'm not in the position to offer that. He's been in custody for some time, I think it's been explained to him that the court would take a look at everything and make a determination, but it's not my intention to offer probation, although I'm very well aware of the fact that the court could place him on probation. If that's what the court does, we'll respect that decision.
So you understand, if you plead to a cap, I can do, again, anything from probation up to 25 years in prison. I know nothing about your cases at this point. So I don't want to give you some false sense of, yeah, plea open to me and you're going to get a probation. I don't know. You could plea open to, or cap at 25 and I could give you the 25. I could give you somewhere in between. I can consider probation. I just can't know those things but right now because I don't have any information. And if you did that, what would happen is if you wanted to enter a plea and take that deal, then we would reset your cases for sentencing. We would get a...
I ain't do what they said I did, no.
Well, if you didn't do it, that's what a jury's for. So we'll get them set for trial, okay? All right, go back with the bailiff. We'll get them set for trial. Is Brittany back there working on something still? Okay, I'm gonna take just a short break. As soon as Ms. Holmes gets finished, we'll take care of her. I think she's got 3 remaining cases and that'll be it. Okay, let's take care of Stephanie Martin. Ms. Holmes? Nuh-uh. You're in court. Don't act like that.
To four cases, dismissing only one.
That's right. Concurrent.
Good morning. Are you Stephanie Martin?
Yes, ma'am.
Give me just a second, please. Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
All right, Ms. Martin, and cause number 20. Let's see, where am I start? Which one's being dismissed?
It's ending in 247, yes.
And cause number 24, DCCR 0248. You're charged with the state jail felony offense of possession of a controlled substance from October 1st of 2023. The indictment alleges that you were previously convicted of possession of a controlled substance on August 24th of 2015. And then after that was final, you were convicted of possession of a controlled substance April 11th of 2016, and also convicted of fraudulent use of identifying information on April 11th of 2016. And how do you plead to that charge?
Guilty.
And are those priors offenses true?
Yes, ma'am.
And then in cause number 23, DCCR 1850, you're charged also with the state jail felony offense of theft with previous convictions. Well, not also, but in that case, that's what you're charged with. And that's from July 14th of 2023. The indictment alleges you were previously convicted of theft August 14th of 2001, March 15th of 2006, September 8th of 2014, August 24th of 2015, April 11th of 2016, July 31st of 2018, January 28th of 2019, and then the indictment alleges those 3 prior other offenses of the possession of a controlled substance in 2 cases and that fraudulent use of identifying information. And how do you plead to that charge?
Guilty.
And are all of those prior convictions true?
Yes, ma'am.
In cause number 250376, you're charged with the state jail felony offense of theft of property with previous convictions. This offense date is from February 7th of 2025. It alleges all of those same prior theft offenses as well as the same prior state jail felony offenses. And how do you plead to that charge?
Guilty.
And again, are those prior convictions true?
Yes, ma'am.
And then finally, in cause number 250375, you're charged with the state jail felony offense of theft with previous theft convictions, and this is from February 18th of 2025. It also alleges all of those same prior theft cases as well as those other prior state jail felony cases, convictions. And how do you plead to that charge?
Guilty.
And again, are all of those prior convictions true?
Yes, ma'am.
In each of these cases, did you enter your pleas of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty in each case because you actually did what they've charged you with?
Yes, ma'am.
In all of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Martin is not competent?
No, Your Honor.
All right, Ms. Martin, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 250375, find sorry, okay. In 30735, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with prior convictions. Find all of the prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 250376, also find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions. Find all of the previous convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 23, DCCR 1850, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions. Find all those prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit for that on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24, DCCR 0248, also find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find all of those prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will all run concurrently, which means together at the same time.
So are we doing all this?
All of it runs
one
at the
time?
same time, yes, ma'am. I will also sign a dismissal in 24 DCCR 0247 as part of that agreement.
Your Honor, if I may, and I'm sorry. to interrupt
Yes,
the
sir.
court. The plea also contemplates the declination of prosecution of the unfiled possession of a controlled substance that appears in BPD number 2025002990.
So the state has also, as part of this agreement, agreed not to pursue that specific case. Do you understand? So there's another possession case out there that Beaumont PD has, but that they haven't, either the labs haven't been done or whatever, it hasn't been indicted yet. What they're saying is they're not going to pursue that case. So it will not be indicted. You're not gonna have to come back here and take care of that case. It's kind of like it's being dismissed before it really gets indicted. Does that make sense?
Yes, ma'am.
Okay. Did I print all four?
Yes.
All right, so I'm going to hand you, in all four of these cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishments I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Yes, ma'am.
I'm sorry, Ms. Rucker. Can I say one, those are my kids right there. Can I just tell them bye?
From here, yes, ma'am.
I'm sorry I let y'all down. And I will see y'all when I come home, okay? You good. I love you, Mitch. I love you.
So, Ms. St. Clair, the thing to do is to take advantage of any opportunity you have while you're in custody, so that when you do get out, you can be a part of their lives, okay?
Yes, ma'am.
All right.
See y'all in 2.5. I love you.
Prestaven Westbrook.
Okay.
Good morning. Are you Prestavian Westbrook? And will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Westbrook, in cause number 25, DCCR 0101, you're charged with the state jail felony offense of theft of a firearm, and that is from November 15th of 2024. And how do you plead to that charge? Are you guilty or not guilty? Well, there's no, I guess, guilty. Did you do it or did you not do it?
When we say stole it, I ain't steal nothing.
Okay. Were you with some people who stole it?
No, man.
Your Honor, he bought a gun that the police checked, and the gun came back as stolen.
Okay.
The probable cause, I'm sorry to step on you, but the probable cause affidavit represents that the defendant indicated to law enforcement that he had some knowledge that it was stolen.
Let me look at that real quick. So did you know it was stolen?
No,
The gun was stolen in 2015, in which he would have been 8 years old. So he did buy the gun off the street. I mean, I guess you can feel like it might be stolen, but he was 8 years old when the gun, in Hardin County. So clearly he's not the one that stole it. But it's indicted as if, he appropriated the property with the knowledge that it could have been stolen, and that's what he was indicted on.
That's the state's position.
So what you told the police was that you bought it for $250 and that you believed it was stolen because that's what other people had told you. Is that right? Okay, so if you didn't know it was, listen, if you didn't know it was stolen, if no one told you it was stolen, obviously you didn't steal it because of the dates of all of that, but if you didn't know anything about it and you were just buying a gun illegally, that doesn't mean that you should plead guilty to theft of a firearm. So I want you to be careful what you say today, because when you were standing over there in front of the clerk, you put your hand up and you swore to tell the truth. And so you can't say, I just want to take this deal and get out of jail, but then stand up and say, I didn't do it. If you didn't do it and you didn't know, then that's what trials are for, and a jury can decide if you either did it or you didn't do it. But if you're in front of me and you want to take this plea agreement, it's going to be because you actually knew what was going on. So you either did or you didn't. Do you want to talk to Ms. Holmes for a minute?
Yeah.
Okay, y'all go visit for another minute, just for a minute though. Let's see, you also have, let's take care of,
Daniel Morgan. He decided to plead, Daniel.
oh, okay, what about Jamal Caddy?
We're gonna need a reset on that.
Do I need to bring him out or anything?
No, it's dealing with priors, cause he potentially may be habitual.
We're gonna reset Caddy, and let's take care of Daniel Martin, and then you can go visit, with Mr. Westbrook, and if you need some time on Westbrook, we'll
Yes, ma'am.
reset it
Cause
for,
that was my whole, I told him not to plead. I was like,
I mean, it doesn't sound like that's,
yeah, that's.
mean, I don't know,
I
but-
told him not to do it, but I think he just wants to get out.
Daniel Martin, yeah. Daniel Martin changed his mind. We said we were gonna reset it, but they still have
Yeah,
them?
he changed his
Okay,
mind. I'm gonna email the attachments.
Thank you. all right, sir, you're Daniel Martin?
Yes, ma'am.
And, let me get this pulled up, hold on a second.
Judge, with the court's permission, may we proceed on count one only on third degree harassment?
Yes, ma'am. Okay. And that's 0299, correct?
Yes, ma'am.
Okay, so Mr. Martin, in cause number 250299, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of harassment of a public servant from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes, ma'am.
And then in cause number 250300, you're charged, and we're going on all of them in that, we're going on,
Is that the state? jail?
yeah.
It- He's playing a 2-year state jail. I don't
So
know.
it's state jail only and not the
Yeah.
priors in that one?
Oh, I see what you mean, Judge, the powers would make him.
Second degree.
On that, that's my error, I didn't flip the page.
That's okay.
Over, I was just
So-
looking at the restitution.
Count one only?
If the court would allow, if not, I'm happy to.
Well, I mean, I guess I'll see what happens at sentencing, I mean, what's the agreement?
It's a
2
time
years
off for
state jail.
2 full-year state jail.
Oh,
It's 2 years on that one and 4 years on the other one.
and the other one, he would be habitual, okay.
If I
But-
need to revisit the offer,
No,
Judge, that's
no, no, no,
that's
no,
my
no,
mistake.
no, I just need to make sure I'm doing it right, I'm sure, I mean, unless you want to revisit it, if you've looked at it and you know what the cases are about, if you're comfortable with going forward with that, that's fine with me.
I am, Judge, if the court is.
Okay.
I think insurance took care of the restitution issues for me.
Okay, so in 250300, the state's also elected to proceed on count one only. In that case, you're charged with the state jail felony offense of criminal mischief from August 29th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I'm sorry?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am. I do.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Martin is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of those pleas. In cause number 250299, find sufficient evidence to find you guilty, and at this time find you guilty of harassment of a public servant. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 250300, also find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes.
Yes, ma'am.
Good luck to you, sir. You can go back with the bailiff. Okay, you want to talk to Mr. Westbrook real quick? I think that's all we got left. On the record. So we're back on the record with Mr. Westbrook, and you had a minute to talk to Ms. Holmes. Ms. Holmes, what's the position?
We'll move forward with the plea.
Okay, so Mr. Westbrook, you were able to talk some more with Ms. Holmes about the law, and so I'm going to ask you the same questions that I asked you a minute ago, okay? You already entered your plea of guilty. Did you do that freely and voluntarily?
Yes, ma'am.
And did you do that because you did what they charged you with? Okay. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you understand those papers?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I say yes or no, please, for
Yes,
the...
ma'am.
That's okay. And so it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation, no fine.
There actually was a $1,000 fine.
Oh, I'm sorry. I
There
didn't
typically
put
is.
it on there.
How much, 500?
It was 1,000, Judge.
There would be,
I'll
how old are you?
500. I'll amend my offer to a $500 fine.
So there would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Westbrook is not competent?
No, Your Honor.
Is there any other history? Obviously, he's young. Anything that you
Judge,
see?
none as an adult that's reflected in my file. There was a 2023 assault as a juvenile, but other than that, that's all the information I have.
Did you get probation when you were a juvenile? What happened on that
There was
case?
a fight at school.
It was. What happened on it because of it? Did you get in some trouble?
I went to juvenile. too many Rogers.
Right.
I don't even think he was that long. I think he was like a day or two.
Right. And then when you got out, did you have to do any kind of probation or anything like that? Okay. Any opposition to me waiving the pre-sentence report?
No, Your Honor.
Okay. Mr. Westbrook, I'm going to again find you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, but I'm not going to do that. I'm going to defer all proceedings, place you on probation for a period of 5 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation. If you do that, this is such a great opportunity for you because you don't have a felony conviction on your record. All right, and if you successfully complete this probation, at the end, the case will be dismissed. You will never be a convicted felon. Part of this probation is going to be that you are not allowed to possess a firearm. There is no reason for you to be out on the streets buying guns, because all that's going to lead to is you being in here for something a whole lot more serious. So you're young, now's the time to direct your life in a whole different way. If you don't like it out there in jail, then stay out by doing what you're supposed to. If you're hanging around with people that are messing with guns and all that, stop doing it. Go to work or go to school, go home, live your life so you can live it like the rest of us. Because here's what can happen. If you violate any condition of probation, you don't follow the rules, you test positive for drugs, you don't show up for your appointments, you get another case, whatever it is, you can be brought back into court. You would be found guilty, so then you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am.
All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Another thing that's important for you to know, Mr. Westbrook, is if you get out there and you do your probation all right at the very beginning, get that community service done, get your fees to take care of everything early. I sign early terminations for probation all the time. Every day I'm signing them. But the only ones that I sign to get off probation early are those who've done everything they're supposed to when they first get started. All right? So get off to a good start, get it all taken care of. You may not even have to be on the whole 5 years. Okay? Good luck to you.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?